Okay, it says on my screen that it's streaming, so I'll take that as my prompt to begin. So good morning, everyone. The inquiry is resumed. Welcome back. Obviously, we're all sitting virtually today just for the purposes of doing closings. Before we start, I think all the documentation that was outstanding has been received now, latterly with the paper on the conditions yesterday. So thank you very much for that. I'll mop up any other procedural points at the end of the session, unless anyone has any particular points they want to raise now. But if not, Mr. Straker, over to you. Inspector Ayres and myself will keep our cameras on during this, just because it's a very lonely world being virtually streamed, so it's a face to or faces to see. So anyway, Mr. Straker, good morning.
Good morning, madam, and thank you very much. And I'm very grateful that you are keeping your cameras on, because otherwise just talking, so to speak, to one's computer can be slightly distracting. I have to confess that I far prefer it when one's in person, but that's a side issue.
Agreed.
Madam, you both should have received, and I trust every other relevant party has now received, a written copy of my final submissions. And
yes,
you obviously will be able to print that out, or we can send you a written copy as is most convenient to both of you. But anyway, I hope you've got it.
And I would just say, sorry, I'm at the far end now of a very long desk. Here I am. I haven't received anything yet, so far as I'm aware. That shouldn't stop Mr. Straker proceeding, but if it could be sent through to my email, I'd be grateful.
Yeah,
it's
well,
actually
certainly
already on as an inquiry document, Mr. Humphreys. That's probably the quickest way of accessing it. So it's already on the INQ 32.
Right.
And I know the programme officer is going to do that with them all, just so that members of the public can follow. So
understood. Sorry about that.
Yes, I am.
Thank you very much. Well, I'm glad that I've been given a number at last.
So, Mr. Straker, if you want to proceed, and also
yes, I will proceed.
Brownie points for sending us a Word version as well, and if the other parties could do that, it would be very, very helpful. So yes, thank you very much for that.
Yeah, well, I hope a Word version is helpful, because it does enable you to lift things out, delete things, add things, and so on. Madam, I start, if I may, at the proper place, which I call the starting point. And the starting point, of course, has to be the legislation, which of course provides the basis upon which the Secretaries of State will have to determine the matter. And this is a Section 73 application. It's that section which gives the starting point, and it's that section which reveals what has to be done to determine the matter. Now, Section 73 was in fact introduced some years ago to overcome a gap in the legislation. If someone was concerned about a condition previously, he could appeal, but to do so would put at risk his permission. And Section 73 enables an application to be made where the only question to be considered, and I emphasize that if I may, is whether the condition or conditions to which the permission should be subject should remain. If the decision maker decides the condition should remain as originally granted, then the application is to be refused. So that gets the point of focus very much on what has been granted. If the conditions are to be altered, then a new permission is granted. The preceding paragraph, which I've just read out, or more particularly Section 73(2)(a), makes plain that the Secretaries of State can leave in place Condition 17 as numbered on the existing permission, which protects amenity, whilst changing one or other of the other conditions. This is perfectly straightforward, and there was some limited discussion, as I put in the footnote, on the last occasion under the label split decision. I'm afraid the response from the London City was unnecessarily complicated and made without reference to the relevant legislative provision, but it is a straightforward exercise. You are entitled to do various things under the legislation, and what you can do is leave in place condition 17 and alter other conditions if you wish to do so. Now, in reflecting upon that particular point, which may bear the label split decision, I'm not sure that's the appropriate legal terminology, but one can use it. In reflecting upon that, one can have in mind that Louise Congdon told the inquiry that London City could reach 8.8 million passengers per annum. That's under the existing regime. Further, Dr. Smith, in a reasoned approach, describes how London City could reach 9 million passengers per annum without extending operating hours. And I've given in the footnote the reference to the relevant documents. I hope I've correctly got them and identified them. I suspect in a number of cases I've just given paragraph references rather than page numbers for fear that I'd get the page number wrong on the basis of past experience. Now, this was not challenged by the London City. Dr. Smith had explained in evidence in chief how 9 million passengers per annum could be achieved within the existing hourly movement capacity of 45. These are plainly important pieces of information, which, if acted upon, would substantially produce the benefits sought by London City without the loss of protection of amenity, which protection was given by the Secretary of State. Now, in any scenario, Madam, the original permission remains in place. If a new permission is granted, there's a choice available as to implementation, although the first permission must have been begun. There is no question but that the 2016 permission has been begun, although not everything that can be done under it has been done. And I'm sure that everyone will bear in mind the difference in planning, but when you begin a permission, it's not necessary to have done everything under the permission at the time of commencement. Accordingly, on a Section 73 application, one starts with the existing permission and particularly the conditions. The reason it can be noted parenthetically why there is an environmental assessment on a Section 73 application is because if granted, a new permission comes into being and the law requires for a development consents having significant environmental consequences, environmental assessment. Now, that all derives from the time when we were members of the European Union and European Union law, which talked about development consents. But it does lead to this point, which I footnote. The position is there can be no doubt but that this is an application for development, for new development. Now, this is a particular type of planning application, and one is determining it one which requires only consideration of condition, but which is nonetheless an application for planning permission. Section 72 tells us what one is obliged to consider on such a determination. However, Section 38(6) of the 2004 Act, and I've given to the legislation just those CD references without attempting any page reference there, but the sections I hope are readily ascertainable. That Act, the 2004 Act, tells us that when regard is to be had to the development plan on an application, the determination is to be made in accordance with the development plan unless material considerations indicate otherwise. Now, it's important to realize that Section 38(6) is not the starting point. It's obviously not the starting point. One starts with Section 73, consider only conditions, then has in mind Section 70, subsection 2, that in dealing with the application, one has regard to the provisions of the development plan so far as material to the application, i.e. the application in respect of conditions and any other material considerations. So one's looking at the development plan so far as material. Now, none of this is to say that the development plan, a statutorily defined set of documents, is unimportant. Perhaps I should just observe, Madam, that I've lost the picture of Inspector Ayres on the screens. I hope.
Apologies, I am here. My video on my tablet is playing up, so I am here. I'm just trying to get it working again. So sorry to disrupt your flow, Mr. Straker.
Not at all, Madam. I thought I'd just mention that, lest it was the case that you weren't actually able to hear.
No, I can hear you. It's just nobody can see me, which probably isn't always a bad thing. But I am trying to make it work again. So please carry on. And
I will carry on, Madam, if I may. Thank you very much. So one starts with section 73, consider only conditions. Then one has in mind section 72, that in dealing with the application, one has regard to the provisions of the development plan so far as material. And of course, one has regard to any other material considerations. Now, none of this is to say the development plan, a statutorily defined set of documents, is unimportant, but it is to say, as the legislation requires, that one has regard to the development plan so far as material to the application. And the application relates particularly to a condition as to noise, which, if changed, as the London City Airport seek, will introduce noise as plain as a pikestaff, that was the expression you'll remember that was used and is unchallenged, into a temporal period, highly valued and considered necessary to be protected from noise for the future by the Secretaries of State. And touching upon that high value, I come subsequently to refer to the statement of community involvement, and you'll have seen the value which is attached to this period of time. I say there are clear breaches of the development plan, which will be highly material in the consideration by the Secretaries of State. But we are considering the development plan so far as material to the application in respect of the proposed discard of a condition which protects amenity by precluding noise, which would otherwise be seriously deleterious. Consequently, we should keep clearly in mind what the Act requires to be done, consider only the question of conditions, and determine whether in effect the extant planning permission should be left in place by itself or be supplemented by another permission, which could, of course, if you were changing some of the other conditions, repeat existing condition 17, viewed by the Secretaries of State as necessary to protect amenity. And so as I footnote there, we're not asked to consider whether the London City Airport is a good thing or whether flying is a social good or a social ill. We're simply not asked those questions. Now, under a heading of vital material consideration, I developed the position as far as what are under the reference other material considerations. But the approach which I've indicated means that the existing conditional permission is a vital material consideration. Students of the law of town and country planning know, incidentally, that even before Section 73 had been introduced, an existing planning permission was a vitally material consideration on a later application. I've referenced that to a case in the 70s. I haven't actually sent along a copy of that case. I've simply given the reference because it's an elementary proposition, but I can do so, of course, if that would be desired. Now, it must be accepted, therefore, that very substantial weight is to be given to the extant planning permission. That extant planning permission was not an idle exercise, but a mature consideration against a definite legal framework which has not changed. Now, it should be noted that the 2016 permission was clearly intended by the Secretaries of State to be something that would persist for a significant period of time. First, the permission as a matter of law inures. I mean, that's the word used in the statute. It's not a very attractive word, but it signifies that it just persists forever. The permission as a matter of law inures for the benefit of the land and of all persons for the time being interested in it. So that's the real starting point. This is intended to last forever. Second, the application on which the 2016 permission was granted made plain that it was a long-term matter. And I've referenced there inquiry document number 17, which is quite an important document as far as this inquiry is concerned. Third, the application was designed to secure the optimum capacity of London City Airport, that derives from that document, fulfill its potential, that derives from that document too, and make best use of the airport. That was all said to the inspector and through the inspector to the Secretary of State, with larger aircraft being inevitable. And I've pointed out in the footnote that the evidence from London City at that inquiry was that there were incentives for quieter aircraft operating through the fulfillment of that permission. So that is that circumstance. And if one then has in mind the relevant text, one can see how important it is. The relevant text, which I've spoken to before, is that the section applies to planning permission without complying with conditions subject to which a previous planning permission was granted. Further, on such an application, only the question of conditions subject to which planning permission should be granted is to be considered. Now, this all plays out in a world of public information and a planning register. The planning register has been extant throughout the lifetime of modern planning since at least the 1947 Act. And it's required by way of a register to be maintained by local planning authorities. And I just want to emphasize, if I may, the great importance of public information publicly presented in legitimate forms, because we have to proceed upon the basis that people will act upon it and will proceed and guide their lives by it. Now, these documents are all public documents. The Town and Country Planning Act 1990 by section 69 and 69A requires there to be a register of applications, and regulations, I've given the statutory instrument reference number to them, require that register to contain the relevant documents. They will also be available through other sources. This register is, of course, available to all, so that, for example, a solicitor acting for a purchaser would be negligent if he failed to draw his client's attention to a planning permission bearing on his prospective purchase. Thus, we can take it as clear, for example, that developers of blocks of flats with balconies would have known of the relevant conditions limiting the adverse effects of airport activities. Further, the purchasers of properties would know, as would lessees and prospective lessees. Now, it is, I'm afraid to say, frankly absurd to suggest, as was done by the London City Airport, that a document viewed negatively by the local planning authority, produced by a business having no statutory or planning status whatsoever, can be taken by those considering property or near the airport as a kind of substitute for official documents, lawfully prepared and lawfully and publicly registered. And as I say, it's to be noted that the document relied upon was viewed with disapprobation by the local planning authority. Thus, there is no scope for the London City Airport to rely on population growth either as supporting a proposition that people have arrived in the knowledge of the airport and therefore have to accept Saturday afternoon noise, or that they have arrived anxious to fly from the airport on Saturday afternoons. And this matter has a further significance. Thus, beyond precluding certain arguments from London City, it reveals the profound impact that planning decisions have on an area and its character. And when planning inspectors or the Secretary of State makes a decision on a planning matter, it does influence the area, and it has a profound impact on its area and its character. And we heard from Mr. Rupert Thornley-Taylor, whose experience, expertise, and authoritative status are all unchallenged and unchallengeable, that London City has never had Saturday PM or Sunday AM flights. So the character of the area, confirmed by the public planning register, is clear. Saturday afternoons, evenings, and Sunday mornings are a time of respite, curfew, relief, or as the appropriate term may be. And we can all bear in mind, of course, I'm sure we've all come across it from time to time, that well-known expression by a member of the House of Lords sitting judicially when he said, context is all. Context is all. And the context here is you get relief in that period of time. Now, we heard from Mr. Liam McFadden, a highly experienced and well-respected planning officer, describe what is kept on the planning register, which is accessible online 24 hours of every day of the year. Now, we might regret the fact that we can access things 24 hours of the day every year, but nonetheless, that is the position. So anybody, whether at midnight on Christmas Eve, alternatively at 5 o'clock on a Friday, can check these matters and would see what I've just described. Now, what would such a person see when he looked for the decision? What is the existing decision? What is the vitally material consideration? Such a person would see that the Secretaries of State for Local Government and Transport had decided to grant conditional planning permission for a very substantial development. The development is set out at paragraph 27 of the letter of the 29th of July 2016 and runs from A to Q, little a to little q. It included demolition, aircraft stands, both upgraded and new, modification of the airfield, and the creation of a taxi lane, extended terminal building, and significantly more besides. As a matter of fact, some of this development has yet to be carried out. And that makes it all the more bizarre, as I say in the footnote, to hear that it's asserted that an incomer should have assumed what the LCY now put forward as their plans, which insofar as they want to remove amenity protection, depend on another planning permission being granted. Now, our visitor to the register would also see that the Secretaries of State gave consideration to the inspector's analysis of conditions and the reasons for them. It can be noted that the Secretaries of State were satisfied that the conditions recommended by the inspector complied with policy. They imposed those conditions. Those conditions had to be necessary and serve a planning purpose. That's a matter of law and also planning policy. When our member of the public, looking at public documents, sees the inspector's, Mr. Whitehead's report, he would notice that the conditions had been agreed and, it may sensibly be supposed, put forward by London City. Mr. Whitehead said the conditions were reasonable and necessary. Our reader would notice by reading condition 17 that weekend relief was both reasonable and necessary to protect the amenity of current and future occupants. And here I do respectfully draw attention to the footnote, footnote 48. When the Secretaries of State, I asked rhetorically, refer to future occupants, did that future merely embrace a year or two? The answer is obviously no. Please have in mind it endures for the benefit of the land, and it's clearly wrong to suppose that one could present the matter on the basis this is simply an exercise which is a year or two, as London City, as it appeared at the end of the inquiry, sought to do. Plainly, that's wrong. Our reader, especially if he had an elementary knowledge of town and country planning, would know that as a matter of law, a condition can only be imposed if both necessary and serving a planning purpose. And I draw attention to a curiosity that no one from London City Airports appears to have thought about this. No suggestion has been made, let alone evidence tendered, to suggest that the conditions imposed had ceased either to serve a planning purpose or to be necessary. In fact, we were told that it was important to protect the amenity that the condition protects, albeit from 6:30, but the amenity presently stands protected before 6:30 is the same as the amenity he regarded as important to protect after 6:30. I draw attention to a ridiculous suggestion being made by the advocate for London City on the 25th of January that no one, so to speak, bothered about conditions in 2016 at the inquiry. Mr. McFadden, to whom the suggestion was made, pointed out that whether or not conditions were carried forward, they had to be properly considered and determined to be necessary to meet a planning purpose. When Mr. Bashforth later gave his evidence, he disowned that suggestion and said the conditions were seriously considered. Now, a member of the public would also notice paragraph 23, that Mr. Whitehead had the advantage of having been provided with very many documents, which are listed over 13 pages. A number of these documents were part of the environmental statement, which of course bears a particular status. You'll recollect that the inquiry we saw for the current environmental statement, it has to be signed off in a particular way. All these documents are available to the public. Now, it's immediately apparent that the London City Airport pursued a need case before Mr. Whitehead and the Secretaries of State. Thus, Mr. Whitehead, in reporting the London City's case, said that the case was that demand forecasts show a substantial and pressing need for certain capacity constraints to be overcome if the airport is to deliver its potential. That was their evidence. London City also stated that the development that found expression in the 2016 permission generated socio-economic benefits such as employment. Remember that much of this is still to be done. The report made by Mr. Whitehead of the case for London City accurately reflected the material, including the environmental statement put before the inquiry by London City. Thus, the need statement, which was a core document before Mr. Whitehead, said it demonstrated that the proposal would be consistent with government policy in securing better runway use. It was stated in bold type that this was particularly so in the context of how best to secure airport capacity in the short, medium, and long term. Now, none of those expressions was defined, as a matter of fact. The need statement was maintained as accurate at the 2016 inquiry. It appears improbable, as I say in the footnote 55, that short, medium, and long term would all have been exhausted in the 7 years since the decision letter of the Secretary of State. An absurd position was suggested by the advocate for London City to his witness in re-examination on the 27th, that long term, despite short term and medium term being mentioned in a document relied upon in 2016, took us only to about 2020, i.e. less than a year after that year by when the permission had to be implemented. Now, the need statement, paragraph 26, was never disowned. It remains publicly available without any suggested qualification. It was produced by a consultant conscious of her obligations, which are owed generally and particularly under environmental legislation. It should be noted that the approval in 2016 was sought to allow a potential of 120,000 noise factored movements per annum. And furthermore, that this appears to be equivalent to 111,000 ATMs, annual travel movements, which of course is what LCY have secured through the 2016 permission, but have yet to reach. And as I note in the footnote, as is well known, there are multiple vacancies for flights or slot every day. Now, if I may, I'll draw some threads together at this stage. Those threads make plain that London City was seen as it is as unique. Mr. Richard Greer told us there is no other airport like it in the United Kingdom, and that its optimum potential is 111,000 ATMs. Further, that it was and is the case that 111 ATMs can be achieved through the permitted flying hours, the bulk of which are on Mondays to Fridays. Furthermore, that the Secretaries of State are determined that a condition to protect amenity by precluding aircraft noise from London City for 24 hours was necessary and reasonable. London City was seeking to say, through the re-examination of Mr. Greer on the 23rd, that Saturday afternoons were no different from other afternoons. Mr. Greer said in cross-examination that the end position, after all his work on the numbers, was that Saturday afternoons, if LCY succeed will be more or less the same as other afternoons. And I just point out that that will be noise as plain as a pikestaff. Thus, that is to say, the proposition of little material difference in respect of noise between Saturday afternoons as proposed and weekdays as permitted, is a very interesting answer. We know that in 2016, the Secretaries of State would have been alive to the fact that all other London airports had Saturday flying. London City is unique. They would have been alive to that fact. They would have known that if Saturday flying occurred at LCY, it would be little different in respect of noise from Monday to Friday. What would have been the difference? The Secretaries of State knew in 2016 that good use should be made of the runway at London City. And as I say in the footnote, I use that expression to avoid choosing between best and better use. The concept is clearly that one should use a runway to take advantage of it in its location so that one does not waste the facility. This is obviously different from a suggestion that best or better use requires a continuous parade of aircraft 7 days a week. And then I give some illustrations from other fields of life. Nonetheless, despite knowing all that about Saturdays, the Secretaries of State deliberately and after due deliberation said at London City Airport, Saturdays will be different, and that such difference related to both the evening and the afternoon. This deliberate decision by the Secretaries of State must be recognised and respected. It is vitally material to our consideration. And moreover, it has clearly been proved to be a wise decision. The heartfelt evidence about Saturdays and the ability to do things on Saturdays can be brought back to mind. And here I ask, if I may, that when in considering this matter, you look back at CD 106, the Statement of Community Involvement, and notice what were clearly heartfelt references to problems arising from the noise and the relief that was provided at weekends from that noise. And one should bear in mind in considering that statement of community involvement that obviously it's a partial document, by which I mean in particular that it can only reference a small amount of the voluminous appearances and observations that were made. One can't readily forget the evidence of Anne Sharp or Teresa Perighetti, which evidence can be taken as representative. And we were all there to hear that evidence at the end of last week. I'm sorry, I'm just looking. I think that there must be a little mistake at the end of paragraph 32, where it says we term. Oh, I do beg your pardon. It's entirely my fault because I've looked at the wrong page. I'm so sorry. So forget what I've just said. There is no mistake at the end of that paragraph. I didn't think there was because I took some care in producing this. It's a sort of teleprompter system, so I blame that. We can also have in mind that 1/4 of all the local authorities across Greater London have objected to the loss of protection from noise on Saturdays. They are well able to respond to the concerns of their population. And I've given in the footnote some indications about the size of Greater London, the number of people, obviously, you know that they will represent, and so forth. Now, the response of London City appears to be, per Mr. Greer, that people complain, and anyway, people can get habituated to noise. In re-examination, it was suggested to him, and he adopted the suggestion, that there were, in any event, other noise sources on a Saturday. Assuming such to be the case, one can note this question, which should have been asked, but wasn't. Were the Secretaries of State and their inspector alive in 2016 to the propositions that people complain, get habituated to noise, and that in and around the Docklands and underneath the flight paths there were on Saturdays other sources of noise. I mean, it's absurd to suppose that the Secretaries of State weren't alive to those facts, but they would have been aware of them, but they still said Saturdays are and will be different. So one can't run away with any suggestion about habituation. One can't run away with any suggestion there are other noise sources, and one can't run away with any suggestion that Saturdays are the same as Fridays. The Secretaries of State said it was necessary to protect amenity. Now, the existing permission, by which I mean the decision letter and the inspector's report, should be studied closely. The relevant permission was for a development that was briefly set out above, that's to say in, I think, paragraph 20 of my submissions. This development plainly enabled the airport to operate in the 21st century. It is apparent there were infrastructure requirements. These requirements enabled the airport to operate as such. The physical requirements were described by London City as being needed to fulfill its potential. Further, an economic rationale was advanced, and I've given you the reference to that. The Secretaries of State, when they came to make their decision, did not describe these matters as need. That word was conspicuously not used. The Secretaries of State weighed environmental impacts against benefits, which included allowing LCY to increase its flights within its permitted level, that is to say 111,000 ATMs, and increase in the likelihood of more efficient aircraft. That's to say, the paragraph provides a useful indicator, as I put out in the footnote, as to the taking of decisions. Despite a prompt in re-examination as to changes in approach after 2016, the position remains that the approach as to balance is the same today as it was then. Now, it can here be noted on the 23rd of January, in re-examination, Mr. Greer said, despite having in cross-examination maintained that any question of need was for another, that the socio-economic benefits in this, the Section 73 case, are greater than in 2016. This, I'm afraid to say, is palpable nonsense. Compare and contrast the need case in 2016 with the need case in 2024. Former can be taken from the inspector's report at paragraphs 94 and 95. They were put by London City through Miss Congdon as physical capacity constraints needed to be met for LCY to reach its potential. Further, in respect of other benefits, compare and contrast Chapter 5 of the still extant need statement produced and relied upon for the 2016 decision with current suggested benefits. And remember, please, to take care to avoid counting benefits attributable to 2016 as attributable to 2024. And when I'm referring to Chapter 5 there, I'm referring to that INQ 17 document. Now, the so-called need case. The need case at the moment is made up of these matters. LCY would like to have Saturday 12:30 to 6:30 p.m. flights. No doubt that would increase the value of the airport to its owners, but there is no maintainable suggestion that LCY needs Saturday afternoons to survive. Second, an airline would like to have Saturday 12:30 to 6 p.m. flights, but there is no maintainable suggestion that the airline or any airline would cease to use LCY if the condition imposed by the Secretary of State were sustained. Third, prospective passengers do not have the possibility of Saturday 12:30 p.m. to 6:30 p.m. flights. Added to these matters is the proposition that if Saturday flights are granted, it will incentivize airlines to move to larger, quieter aircraft. Although, of course, that's been said to be inevitable beforehand. Further, Mr. Bashforth repeatedly said that although he was not an expert, Saturday afternoon opening assisted rotational use of aircraft. Let's have a look at that. Business case or benefits for some. Need, which word was not used by the Secretaries of State in 2016, is clearly the wrong word to use. And I give, by way of little incidental there, a reference back to the Mikado, which we'll all remember. The matters advanced are at best benefits for some persons. These benefits, such as they are clearly outweighed by other considerations. However, let us consider these suggested benefits, and in doing so, consider matters to whose existence they do not contribute in the slightest. They are not necessary for the continuation of London City Airport. There is no sensible suggestion by London City Airport that such is the case, although footnote 90, Louise Congdon did say in cross-examination, you never could tell. She was making the point that forecasts can be difficult as the future is not known. Second, there is no evidence that such is the case. Third, there is an extant permission which, according to LCY, secured the full potential of the airport. The benefits are not necessarily for the continuation of any airline, whether the one cited by LCY or at all. And parenthetically, it's not understood why the planning system, which operates in the public interest, should be used to aid the economic performance of an airline or any airline. First, the benefits identified are not necessary for the viability of or continuation of any airline. This is not so suggested, and there's no evidence to that effect. Second, in any event, it is undisputed, but that there are plenty of slots on every day that LCY operates. That was confirmed by Ms. Congdon when she gave evidence, which could be taken up by airlines if they chose to do so. LCY complained that an airline gave up use of LCY, yet concurrently asserts that airlines cannot presently meet demand. Now, Dr. Smith, whose evidence was clear and is to be commended, pointed out the following. Just one point that I make here, but obviously you'll want to study his evidence closely. The difference per aircraft would be a financial improvement of just under £200,000 per annum for the airline shareholders at the expense of Saturday afternoon disturbance. Accordingly, I say that a simple desire by LCY to have Saturday afternoons is a matter of no planning consequence, save to say that to meet that desire would undermine a matter seen by the Secretaries of State as necessary for a planning purpose, that is to say, the condition which secures no aircraft movement between 12:30 Saturday and 12:30 Sunday. Further, the desire of an airline or airlines to operate during part of that time is a matter of no planning consequence, save to say that to meet the desire would undermine a matter seen by the Secretary of State as necessary for the planning purpose, the condition mentioned in the preceding paragraph. This leaves the third supposed benefit, namely meeting the desire of those living within the catchment area of LCY to travel on a Saturday afternoon to or from destinations not now serviced during the rest of the week from London City. Ms. Congdon, when asked how this had been itemised or determined, in the absence, for example, of any representation by a putative leisure traveller, said repeatedly that this is what the airline said. Now, there are a number of difficulties with this supposed benefit. It is predicated on the proposition that the leisure travellers in question will only take off or land on a Saturday afternoon. This only has to be stated to be shown to be nonsense, and in any event is contradicted by the evidence of LCY, who maintained, although not to very good effect, that one could not and should not distinguish between any weekday and Saturday. There is no material whatsoever to support the proposition that there exist putative Saturday afternoon only travellers. If there were, why should something viewed as necessary to protect amenity be removed to accommodate the person who says, I will not travel by air at any time other than Saturday 12:30 to 6:30, and furthermore, I will not travel from any airport other than LCY, despite the proximity of the Elizabeth line and cheaper fares elsewhere. LCY are frankly clutching at straws. It can be accepted as realistic, however, that there are people in and around LCY who would like from time to go on holiday. I expect that's true of most of us. It can be accepted that some such people may view the present leisure destinations furnished by London City with disdain and distaste. But who would not view other destinations in such a light? In other words, they view the present ones in that way, but other ones would be fine. Now, we know remarkably little about these people because London City have not condescended to produce any material, bar the assertion, per Louise Congdon, it was a recurring theme in her evidence, that the airline has said so. It can be accepted, however, that some people may find it more convenient to get to London City than, for example, to take the Elizabeth line to Heathrow. Now, the previous paragraph is, because it has to be, because none have been provided, devoid of numbers. None has been provided by LCY or its favoured airline. However, we do know there are multiple slots available every weekday, Monday to Friday. If there are leisure travellers in and around the airport falling into one or other of the groups mentioned in the preceding paragraph, then an airline could simply take one of the slots and fly to the new beach or leisure destination, presuming it's one that won't be treated by those travellers with disdain or distaste. The fact this has not happened tells us a great deal. It tells us that this supposed benefit or desire for leisure has not been sufficient to be responded to by LCY or any other airline. We know one airline's dropped out altogether. It tells us that LCY want the benefit of further potential utilization of the airport, even though the local market doesn't generate that utilization on a Monday to Friday. It must be remembered there is an obvious pecuniary advantage to the airport, whether on a prospective sale or otherwise, in having secured release from the Secretary of State's condition. It tells us, in short, that the supposed benefit of this application as a response to desired local leisure travel is illusory. Now, I then come to touch upon the question of forecasts. It can here be noted that the forecasts put forward by London City through Louise Congdon are fraught with curiosity. They were presented in a peculiarly solipsistic way. She relied, for example, footnote 103, on the proposition that she'd been on a train from Manchester to London or the other way around, and there were other people who appeared to be business travellers, and therefore business travel had resumed. And they were, to a considerable degree, these forecasts, based on propositions that are either laughable or manifestly wrong. The most egregious was the proposition that the elasticity on which the forecasts were based, prepared on material that predated 2020, we all know the significance of 2020, or any reference to COVID, nonetheless took account of COVID and any effects that had on the way people operate. That's an amazing statement, which is obviously laughable and wrong. It should also be in mind that the forecasts depend on a variety of factors, including gross domestic product. The approach of LCY appears unduly optimistic. Now, on the other hand, Dr. Smith's evidence should be carefully considered. He was condemned by Louise Congdon for giving his opinion. However, this is what he was asked to do, offer an independent expert opinion, and that's what he did, without being beholden to anyone or any previous set of documents. He drew attention to clear risks in the forecasts and drew attention to deficiencies in the position of Miss Congdon and the London City Airport. The fact he indicated that an approach could be followed doesn't undermine, but rather emphasizes his cautionary observations. It is next necessary to inquire whether the supposed incentivization of larger, quieter aircraft materially aids the position of London City. It is clear it doesn't. First, it has all been said before. Secondly, inevitably, quieter aircraft will come forward for economic reasons. They're bigger, cheaper to run, you can pack more passengers in it and get more money accordingly out of each flight. Accordingly, the benefits or asserted need case for the London City Airport is hopeless. Next, we can consider the question of noise. Fortunately, this matter can be approached very straightforwardly, as there are agreed, unchallenged, or unchallengeable propositions. The basic and agreed propositions are that noise is important. I just want to emphasize that, if I may. We are talking about something which is actually desperately important to people. Noise can cause a serious loss of amenity, and the noise referable to the application is as plain as a pikestaff. Further, there is a distinct amenity necessary to protect. This derives from the extant planning permission and the decision of the Secretary of State. It's an acknowledged amenity which is necessary to be protected. Second, the noise on a Saturday afternoon shouldn't mimic the noise on a Monday to Friday. This also derives from that decision, Secretary of State's decision, but is reinforced by, amongst other things, the statement of community involvement, evidence to the inquiry, representation to the local planning authority, and general notoriety that Saturday afternoons are different from Monday to Friday afternoons. For example, do the school children hereabouts go to school on Saturday afternoons? If they do, is it only for outdoor fixtures against other schools, matches and so forth and the like? Third, the evidence from LCY is that amenity post 6:30 on a Saturday is important to protect, and that the amenity being protected between 12:30 and 6:30 is no different, save that such amenity is more likely to have hours of daylight. Although people have a propensity to be indoors, or so it is said by LCY, they made sweeping observations, as I record, in footnote 108 about the behavioral habits, but cause no social scientist to verify them. There is a greater likelihood of being out of doors during hours of daylight. That's not an alarming proposition, one trusts, but a matter of elementary sense. There is no need to worry about the figures produced in the ES or by Mr. Greer. It's agreed that the Saturday noise would be similar to the noise on Mondays to Fridays, and unchallenged, but that it would be as plain as a pikestaff. And then footnote 109, if I may just draw attention to that, please, the evidence of Mr. Thornley Taylor. His professional position stands supreme, and what was peculiarly refreshing to hear was an expert say, as all experts ought to say, I am here to give my advice in accordance with my expertise. It is not for me to advise, let alone tell, a decision maker how she should weigh the various factors, some of which will not involve my area of expertise. Compare, I say, the evidence of Louise Congdon and Richard Greer. The benefits evidence should simply have said these are benefits, and the noise evidence should simply say this is the noise. The evidence gets muddled when it departs from that dynamic. This was shown vividly in the evidence of Mr. Greer when he was trying to justify where one deserved protection from noise at, for example, 6:30 p.m., but not at 6 p.m. Not when we have British summertime and so forth, those questions which arise, an hour which is protected one week but not the next. Maybe, anyway, that is an important point to bear in mind, and Mr. Thornley Taylor did his profession credit and himself credit and recognized the important point by saying what he said to you, Madam Inspectors. Now that left the text at footnote 109, paragraph 61. We know what the level of noise is, and we know that according to LCY, it's important to be prevented on Saturday evenings. Further, we know that such noise causes disturbance. Further, we know it's agreed there is no metric capable of providing advice. This was said to be by Mr. Greer to be why something else had been done. Simply because one hasn't got a mechanism for something doesn't mean one does something entirely different. But this was said by Mr. Greer to be why something else had been done. However, that something else is a 16-hour approach based on existing aircraft noise in order to consider a 6-hour period where there is no aircraft noise. The solution does not relate to the problem. However good Mr. Greer may be with numbers, we are no further forward. It is as well to remember that pikestaffs can determine outcomes. Now, it's worth here making an incidental observation about sleep deprivation, and this is where Mr. Thornley-Taylor has been clearly misunderstood. Mr. Thornley-Taylor made plain that the ES finds that in several locations there are increases of up to 2 dB in summer, LAEQ 8 hours, which, if there is no major seasonal variation, is equivalent to L night, but the additional population, which is likely to be highly sleep disturbed, is not reported. You can just look through the ES for that purpose. The research which led to these figures did not take into account whether or not the residents studied had sound insulation installed in their homes. If that were taken into account, the percentage high sleep disturbance could be less than reported in the WHO England. But one doesn't know. Mr. Greer gave the surprising answer in cross-examination that if all dwellings had sound insulation, there would be zero sleep disturbance, although that proposition was not in his written evidence. If such were the case, the government's continuing efforts to reduce night noise arising from airports would seem somewhat superfluous. The critical point is that the research did not take into account whether residents had sound insulation. The answer that comes back from London City Airport is to the effect that if everybody has sound insulation, all will be well. And Mr. Thornley-Taylor agrees that if such is the case and all are using functioning sound insulation, this particular aspect of the harm caused by the proposal is lessened or avoided. However, we all know the world is not perfect. At least I hope we all know the world is not perfect. Otherwise, we're going to get in an even bigger mess. We all know the world is not perfect, that some will not have sound insulation, that some will have it, but it will not work perfectly, or some will have it but still want an open window. Accordingly, the Secretaries of State should conclude that the early morning noise will be increased so that it consists of 6 flights of any description of aircraft and 3 flights of newer and one hopes quieter aircraft, rendering it probable, given the improbability of all having sound insulation, that there will be sleep disturbance. Further, the Secretaries of State should also conclude that there will be intrusive noise seriously adversely affecting amenity on Saturday afternoons. This noise can properly be described as plain as a pikestaff. I can now move to the question of planning, which is linked to the balancing exercise being performed. The critical point to draw from planning policy is the great weight given by policy to 2 propositions. First, that aircraft noise is a matter of great seriousness within development plan policies, and I footnote as to why that is obviously the case. Second, that development plan policies recognize the amenity damage caused by such noise, leading to the desiderata of avoiding or precluding such noise. The development plan policies mentioned in the reason for refusal are D13 and T8 of the London Plan and SP2 and SP8 of the Newham local plan. I deal with them in sequence, and just before I do so, can we please bear in mind there was an erroneous suggestion made in answer, I think, to Haycan, or in connection with the Haycan point, that somehow or other what a witness said about a plan policy was binding. It's not, absolutely not. That was obviously a half-remembered point of the law of evidence relating to the credit statements about a witness. The fact is, the questions of these development plan policies and their interpretation is a matter of law, and you can decide what these development plan policies mean, and you should decide what they mean. It's your decision. D13 is the agent of change point. This policy is plainly intended to deal with the common law principle that coming to a nuisance is no defense. In other words, if I build my house next to a factory and then sue the factory for nuisance, the factory can't defend on the basis it was built first. Thus, and inevitably, the policy distinguishes between existing noise and new noise. It is obvious that we are here concerned with new noise. It's absurd to say that because there is noise on Saturday morning and you need planning permission to make noise on Saturday afternoon, then the noise on Saturday afternoon is existing noise. Are we to tell the Secretaries of State who considered the matter so carefully in 2016 that notwithstanding their care in precluding noise, they are to be taken as having created existing noise? What is the point of seeking planning permission? What is the point of the planning register? What is the point of LCY saying and seeking permission on the basis that the optimum use is 111,000 ATMs Monday to Friday with Saturday mornings and Sundays after 12:30? This is new noise. You can test that by asking what would happen if LCY broke the condition. Would they be able to defend a breach of condition notice on the basis the noise was existing noise? The district judge would laugh at the advocate who put that forward. Clearly, D13C and D13E are relevant. C says that new noise and other nuisance-generating development proposed close to residential and other noise-sensitive uses should put in place measures to mitigate and manage any noise impacts for neighbouring residents and businesses. Please notice that noise is categorised as it is as a nuisance. Certain questions need to be asked in considering whether D13 has been breached. Has it been clearly demonstrated that the development proposal will mitigate and manage the noise? The answer is plainly no. We are concerned with noise in the afternoon. When asked about funding for outdoor facilities, LCY have to say that those using the facilities will still hear the noise. Further, there is no recognised means of assessment. Judgment has to be used, and the approved judgment is that the noise will be as plain as a pikestaff. Further, the amendment to the proposal by the LCY is predicated on the noise on a Saturday evening being significantly deleterious. This is the same noise which is proposed to be introduced, contrary to the Secretary of State's decision in 2016, for Saturday afternoon. The amenity is to be protected in the time before the proposed condition takes effect is more noticeable, given it is during daylight. The pikestaff will be present and will not be sheathed in any way, not managed or mitigated. It should be noted that by D13E, one should not normally permit development proposals that have not clearly demonstrated how noise and other nuisances will be mitigated and managed. Given that such is the case, refusal is indicated. On the metaphor, as I say, the pikestaff has not been sheathed in any way. There is no mitigation and management. Now, T8 is conspicuously breached. It's the policy of the London Plan that deals with aviation. In considering the weight to be given to this policy, please bear in mind that this plan went through a long inquiry process with several inspectors and had to gain the approval of the Secretary of State, who had the power to stop it, to delay or stop it. Plainly, this proposal is for airport expansion, whether or not one has in mind that the 2016 permission constituted optimum capacity. It follows that there should be an overriding public interest or no suitable alternative solution. The overriding public interest, is said to be those commercial benefits to the airport and the airline, and such socio-economic benefits as can be derived from this application, if permitted, and are additional to those derived from the 2016 permission. T8 has, of course, to be read and considered as a whole. It is never appropriate to pick out a little from a text and assert it represents the whole. Naturally, one reads the policy in the context of the London Plan as a whole, taking any account of any words that are glossed in the plan. Now, T8H helps us realise how seriously noise is viewed. Very seriously. It can be recognised that the first sentence in the light of the glossary is, at least principally, dealing with something different from the proposal here pursued, but it helps us to recognise the care that is needed before there are changes in circumstances which generate environmental harm. It's perfectly clear that such harm does here exist. This is expressly acknowledged by London City through their evidence about the importance of the proposed condition, and they're bringing forward just under £4 million to help outdoor leisure areas, even though it's acknowledged that such help does not preclude the noise from being heard. However, T8H consists of, and please do look at this subsequently, two distinct and separate sentences, each of which in the ordinary way carries its natural meaning. The second sentence says, any significant shift in the mix of operations using an airport, for example, the introduction of scheduled flights at airports not generally offering such flights, as an example, should be refused. So any significant shift in mix of operations should be refused. Please notice this policy refers to any, that is the word used, significant shift in the mix of operations at an, the indefinite article is used, airport. An example being recorded is given. That's an example. It's not determinative of the whole exercise. The city airport is clearly an airport, which proposes significantly to shift operations to include in its mix Saturday afternoon flights. Consequently, T8H is important on two counts. First, because it directly suggests refusal, and second, because it shows the significance of aircraft noise. Thus, there are clear breaches of the London plan. The Newham local plan has at SP2 a policy supporting the need for certain types of facilities. Noise would be deleterious, obviously. SP2 indicates what is needed. This includes attending to environmental impacts such as noise. Are we seriously to say that attending to environmental impacts secures allowing noise as plain as a pikestaff, where hitherto such noise has been precluded? Are we seriously saying that? So please write in, say that attending to environmental impacts before the word secures. SP8 seeks to ensure neighbourly development, which this is not. We know it's not. You've only got to flick through the statement of community involvement to realise that. SP8 reveals an expectation that development avoids negative environmental impacts, which obviously include noise. Is it neighbourly to overfly people on a Saturday afternoon? Is it avoiding negative environmental impacts to do so? Obviously not. Accordingly, I can draw some further threads together. We have seen that the need case is hopeless, and that the best that can be said about the benefits case is that it's overstated. The noise case reveals intrusive noise against which there should be protection, and the planning case reveals on the balance overwhelming deficiencies on the part of LCY and clear breaches of the development plan. So I now, if I may, move to a conclusion. First, what is the question? The question is whether, having regard to the development plan so far as material, and bearing in mind other material considerations, should a planning permission be granted subject to different conditions from those judged necessary in 2016? The development plan, so far as material, indicates refusal, but this allows for the possibility of an overriding case in the public interest as a material consideration overcoming that indication. But that supposed case in the public interest is no more than a flawed business case and a limited amount, bearing in mind the existing permission. You've always got to bear in mind the existing permission in considering these matters. Limited amount of socio-economic benefits. Further, other material considerations, in any event, strongly indicate refusal. These other material considerations include the existing permission, which allows an airport satisfactorily to operate, and was predicated on the proposition advanced by the London City Airport that the permission secures optimum, that was the word used, optimum, the best, optimum use of the airport. Other material considerations include multiple points of impact on public and private activities on Saturday afternoons. Just cast your mind around what people do on a Saturday afternoon, all the varied activities and so forth, and all the multiple points of impact, together with some likely sleep deprivation. These impacts have all been vouchsafed by the multitude of representations by members of the public and representatives of the public. There is nothing that serves to override those considerations that militate against permission. Accordingly, permission should be refused, or at the least, condition 17 in its existing form ought to be preserved so as to secure that protection for Saturday afternoons. Now, that concludes my submissions. I very deliberately didn't go through the footnotes, but I do invite reference to them when you come to consider this as a written document. And of course, I'm anxious to, if there be any questions, to try and respond to those. But otherwise, even though I haven't used my time, I can bring my submissions to a conclusion. So I'm very grateful to you for listening to me so carefully. Thank you very much.
Thank you very much, Mr. Straker. And yes, you've come in under the countdown clock for a one final reference for the final day. So thank you for that. I have no questions for you. And of course, as with all the proofs, we will be sorry, not proofs, the closings. We will be reading them very carefully and looking at all the footnotes as well. So thank you very much. So next we will hear from Hakan. What we will do is actually we'll stick to the allotted times because they have been publicised. So people might be actually just dialing in at 11:30 to specifically for that. So we'll stick to that rather than bringing Dr. Lane forward. So we'll adjourn now until 11:30 for the Hakan's closing. But in the meantime, thank you very much, Mr. Straker. Thank you.
Thank you, madam. Thank you.
Okay, I'll unmute myself before I start. Okay, welcome back, everyone. So we will now hear the closing statement made on behalf of HACAN by Dr. Lane. So Dr. Lane, if you're ready.
Madam, thank you. And I make this closing statement on my own behalf and also on behalf of Mr. Hahn, who is not with us virtually today. On the opening afternoon of this inquiry, Sir Stephen Timms, the MP for East Ham, described how it had, quote, always been part of the deal, unquote, that London City Airport would close for 24 hours at the weekend between Saturday lunchtime and Sunday lunchtime. Having negotiated the original planning conditions as Vice Chair and then Chair of the London Borough of Newham's Planning Committee in the 1980s, he explained that the weekend curfew was the price that the airport paid for being situated in the middle of a densely populated residential area. He characterised the current appeal proposal as a fundamental breach of an understanding that the airport had reached with the community from its inception. HACAN East has made it clear throughout its evidence to the inquiry that London City is unlike other UK airports, and the current appeal proposal, unlike other recent aviation expansion proposals, in a number of key respects. London City relies more heavily on business passengers than any other UK airport. Its passengers also have higher average household incomes than those for any other airport serving London, despite London City being situated in an area with high levels of deprivation. Its flight paths are unusually concentrated and feature an unusually long level flight segment, with arriving aircraft during easterly operations passing over southeast London at 2,000 feet for many kilometres. This expansion proposal also falls to be determined in accordance with Policy T8 of the 2021 London Plan, and the local planning policy context is therefore different from other recent aviation appeals. National aviation policy is clear that while the government is broadly supportive of aviation growth, within a framework which maintains a balance between the benefits of aviation and its costs, it is for planning decision makers to weigh those benefits and costs in relation to individual proposed expansion schemes. In so doing, they should take into consideration a scheme's environmental and economic impacts and any proposed mitigation measures. HACAN East's view is that the economic benefits of the appeal proposal have been HACAN East's view that the economic benefits of the proposal have been overestimated has been vindicated by the evidence. Its evidence has also shown that the environmental costs of the proposal would be more significant than the appellant acknowledges, and that the mitigation proposed to meet those costs is both inadequate and uncertain. Both in respect of the anticipated socioeconomic benefits of the appeal proposal and its predicted environmental harms, the appellant's case is shot through with uncertainty and characterised by a pattern of convenient assumptions. Nothing in the evidence before the inquiry justifies the fundamental breach of the understanding between London City and the community that Sir Stephen Timms identified. These closing submissions will be structured to reflect the order that the oral evidence was heard in. So I'll deal first with the socioeconomic impacts of the proposal, then the effects on noise, and finally compliance with the development plan, including in respect to climate change and the planning balance. On the socioeconomic evidence, the appellant has taken pains to frame the appeal proposal as a leisure-focused expansion throughout much of its evidence. Mr. Bashforth characterised it in this way multiple times during his oral evidence. The Need case states that adjusting operating restrictions is likely to result in airline operators changing their Saturday focus to leisure-type routes. And in Ms. Congdon's recent note, responding to Dr. Chapman's additional note, which is Inquiry Document 25, and Ms. Congdon's note, Inquiry Document 28, she referred to the more extensive portfolio of leisure services that the airport would be able to provide if permitted to expand. However, Dr. Chapman's Inquiry 10 document which analysed the data in the appellant's response to the GLA Stage 1 report, indicates that London City, in fact, predicts a higher proportion of business passenger growth by 2031 in the with development scenario than in the do minimum scenario. When questioned on this during her oral evidence in chief, Ms. Congdon stated that the proposed expansion of the airport would allow it to put on a number of new business routes, and that, quote, creates opportunities for business passengers who can't use London City at the moment to use London City. So the with development case tilts slightly towards business passenger growth being a bit stronger proportionally than leisure passengers. This inconsistency in the extent to which the appeal proposal is anticipated to be leisure or business passenger orientated is a symptom of the broader ambiguity from the appellant regarding what the appeal proposal is actually for. To quote Mr. McFadden in his oral evidence, what was provided to the London Borough of Newham was a business case, not a need case, and we've already heard that this morning from Mr. Straker. London City has been inconsistent regarding whether the appeal proposal is primarily designed to incentivise leisure or business passenger growth, and has not provided convincing evidence that it is actually required in order to do either. Even if there were greater certainty that the appeal proposal is primarily intended to be a leisure-focused intervention, increasing connectivity for business passengers remains a key part of the need case document. This is significant for three reasons. First, because there is every reason to think that the projected growth in business passenger numbers will not materialise, given past trends in business passenger growth and substantial structural shifts in the economy affecting underlying demand for business travel. Second, because airport capacity constraints tend not to materially impact business passenger numbers, even where underlying demand growth is strong. DfT's and the Department for Transport's analysis in its 2017 aviation forecasts, to which Dr. Chapman drew attention in his evidence, indicated that business passengers can be expected to continue to fly regardless, even in a capacity-constrained scenario, due to their greater willingness to pay. And third, because even if this expansion scheme did produce net additional business passenger growth, Dr. Chapman has demonstrated that the consequent GBA growth projections are based on a substantively outdated model concerning the relationship between business passenger growth and GBA growth. Table D6 of the need case presents the growth rates of different market segments assumed within the appellant's central forecast. As Dr. Chapman highlighted both in his proof and oral evidence, the trajectory shown for travel for business purposes are simply not credible. The need case predicted that business travel demand would already have recovered to pre-pandemic levels by 2023 and would increase to 20% above pre-pandemic levels by 2025. The reality is very different. Right now, legal restrictions due to COVID have been lifted almost everywhere. GDP is back to pre-crisis level in real terms, and leisure air travel has bounced back, but demand for business travel has not. It remains 28 to 31% down on 2019, as the appellant's own evidence shows. As regards future growth in business passenger numbers, Dr. Chapman's report, Losing Altitude, demonstrates that business travel has not merely slowed in recent years or in response to the pandemic. It has never recovered from the 2007 to 2008 financial crisis. A chunk of the market simply never returned after 2008, and another chunk may well not return after COVID. Business passenger projections for the present appeal proposal are based on a predicted demand model which simply does not account for the structural shift which occurred in the business travel market after the financial crisis. The appellant did not, in fact, challenge this analysis. In the aftermath of the COVID pandemic, with remote working and teleconferencing more ubiquitous than ever before, there is no reason to suppose that this 17-year trend will suddenly reverse. This is not even taking into account the potential for substitution of passengers who may prefer to use newly upgraded rail routes, such as the Eurostar service to Amsterdam, an effect which the appellant did not model for. Ms. Congdon suggested that the decision not to model rail was made because trains are not competitive with flights on routes taking longer than 3 hours. But this is contradicted by the success of Eurostar's recently launched direct routes to Amsterdam and Rotterdam. Even if business travel growth were to exceed all expectations and return to pre-financial crisis levels or above, the relationship between business passenger growth and GDP is much less clear-cut than it once was. Generally, it is understood that business passengers produce greater economic benefits than leisure travellers. But Dr. Chapman has highlighted the dangers inherent in an uncritical reliance on the statistical relationship between business passenger numbers and economic output that is presented in Table 6.7 in the need case. In particular, he noted that the elasticity used by the appellant, developed by Oxford Economics in 2013, relies on input data spanning 1980 to 2010, which was a period of booming business travel growth overall. The other survey cited by Ms. Congdon in her rebuttal proof at paragraph 3.4.4 also rely on old data. In the UK, the number of business air trips per £1 million real GDP has been declining since at least 2006. In her oral evidence, Ms. Congdon presented this as a positive, suggesting that it indicated that each individual air trip generated a greater increase in GDP than previously. However, no evidence was presented to support this causal inference. Indeed, in direct contradiction of this assumption, Ms. Congdon herself appeared to accept that since the pandemic, a chunk of the business travel market has dropped away as the relative advantage of air travel over digital communication has declined for certain routine business functions. This supports the conclusion drawn by Dr. Smith and Dr. Chapman that rapid advances in digital communication and the accompanying business culture shift have reduced the relative benefits that arise from business air travel. Taken together, this demonstrates that the appellant's evidence on this point is unreliable. At the very least, a more up-to-date analysis than the outdated Oxford Economics model should have been used. On displacement and substitution, the appellant assumes both 100% displacement and 0% displacement at the same time. On the one hand, assuming that displacement of aircraft and therefore climate impacts will be 100%, and on the other, 0% displacement of jobs and GVA. In oral evidence, Ms. Congdon suggested that there would be effectively 100% displacement of air traffic and 95% displacement of passengers. These assumptions were not made clear anywhere in the evidence submitted by the appellant before the inquiry, and Ms. Congdon accepted in cross-examination that the underlying calculations had not been provided. Ms. Congdon's response to Dr. Chapman's additional note indicates that her carbon costing estimate in fact assumes 93.5% displacement of air traffic. Meanwhile, the need case effectively assumed 0% displacement of jobs within the local study area. These figures do not stack up. In every case, the underlying assumptions are those which favour the appellant's case and are left opaque and uninterrogated within its written evidence. The implications of this for the claimed benefits of the scheme are significant. First, the assumption of over 90% displacement of passengers is central to the extent of the benefit to travellers in quicker travel times to London City. That one assumption drove a large part of the appellant's case and formed a high proportion of its overall calculation of the scheme's net present value, or NPV, yet it is never actually justified. Second, the appellant has never acknowledged the impact of the high passenger displacement estimate on the anticipated social welfare benefits of the appeal proposal. More than 90% displacement of passengers means that only a small minority of the anticipated passengers who will be new to London City in the development case scenario would actually enjoy the benefits of flying as a result of the appeal proposal. The vast majority would travel anyway, regardless of whether the proposal is permitted or not. Third, the appellant has assumed 0% displacement of jobs within the London study area, but if 93.5% of passengers would have flown anyway on the do minimum case, then the majority of jobs predicted to be created by the appeal proposal would likely have been created within London in any event. Regarding carbon costs, the assumption of near total displacement of air traffic is not credible. Overall passenger numbers in the UK have grown rapidly over time, and the forecasts in this application are specifically predicated on there being significant future demand growth across the economy. Unlocking further growth with new capacity means additional air travel on new planes. This is supported by international air traffic trends. As Ms. Congdon highlighted repeatedly in her oral evidence, the airlines flying from London City are international airlines and are subject to international commercial realities and trends, including the rapid growth of the global commercial aircraft fleet. There is no logical basis for assuming that expansion at London City does not ultimately increase the global demand for aircraft and the distance travelled by the global fleet. Previous expansion applications at London City have failed to deliver projected employment gains. In evidence in chief, Dr. Chapman explained that the 2008 application for permission to expand capacity at that time from 2.5 million passengers per annum to 3.9 million passengers per annum was estimated to support 2,277 full-time equivalent jobs, but that the reported jobs numbers for 2019 in the 2021 London City Annual Performance Report tell a different story. The airport's passenger throughput in 2019 was 5.1 million passengers per annum, so over 1 million more passengers than had been permitted by the 2008 application and permission. Yet the full-time equivalent jobs figure for the same year was 2,036, which is some 240 below the jobs prediction for 3.9 million passengers per annum. In her rebuttal at 3.5.6, Ms. Congdon acknowledged that, quote, it was recognised in the original CADAC 1 application that the growth in employment anticipated in 2008 had not fully materialised, unquote. But she attributed this to an unforeseen step change in productivity due to restructuring of functions, e.g. increased automation following the global financial crisis. The appellant's evidence does not contemplate whether the aftermath of the pandemic may give rise to another step change. Haycan East contends that there is every reason to doubt whether the projected employment gains from the present appeal proposal will in fact materialise. In respect of indirect and induced jobs in particular, the assumption of 0% displacement is likely to have significantly influenced the assessment of predicted employment growth. In his evidence in chief, Dr. Chapman gave the example of jobs in factories making food for planes and explained that these jobs are still likely to be created regardless of whether or not the ready meals and sandwiches being produced are consumed on aircraft flying from London City or from Stansted. But the appellant is not controlled for this factor. In re-examination, Ms. Congdon stated that a low multiplier had been used when modelling how much of the supply chain for London City was likely to be localised, and asserted, without evidence, that it's unlikely that that local supply chain would be in turn feeding Stansted. Dr. Chapman also noted that many of the new jobs projected to be created by the appeal proposal are in retail and hospitality, and that these two sectors are prime candidates for displacement. If a potential London City passenger did not fly and instead went to work, they would still buy their morning coffee. They would just buy it on their way to the office rather than at the airport. The appellant has repeatedly touted the support in national aviation policy for the broad social benefits of flying, even where it leads to an overall economic deficit from outbound leisure tourism. However, losing altitude shows that pre-pandemic, an estimated 70% of all flights were taken by just 30% of the population, with individuals aged 19 and younger notably underrepresented in the flying group at just 6.4%. This is not just Dr. Chapman's view, as was suggested by Ms. Congdon. It is evidenced by CAA data, and this includes the undisputed CAA passenger income figures provided to the inquiry, which show that London City passengers are far wealthier than those travelling from other airports serving London. Nevertheless, the appellant has undertaken no analysis of the equity of the socio-economic impacts of the appeal proposal, with Ms. Congdon stating during cross-examination that she did not consider it to be necessary. It is Haycan East's case that far from a broad social benefit, what is actually offered by the appeal proposal is a narrow social benefit, mainly enjoyed by a group of older, wealthier, frequent flyers. If the appeal proposal is permitted, then statistically, the average Newham resident annoyed by new noise from London City aircraft on Saturday afternoons will earn less than the passengers flying above them. Turning then to WebTag, which has been a subject of much debate at the inquiry. Dr. Chapman was very clear that WebTag is not a binary yes or no tick box exercise. Rather, it is a best practice guide that allows the socio-economic impacts of both government and non-government aviation interventions to be more fully understood. The appellant has obviously appreciated its worth too, since they've utilised WebTag methodologies and referred to the Green Book at points in their evidence, where they deemed them to be useful or convenient, notably in relation to carbon emissions. Ms. Congdon accepted in cross-examination that WebTag is not something that is solely to be used by the Department for Transport, and that it might be useful to other appraisal practitioners. In fact, all parties are now agreed that it is open to you, the inspectors, and the Secretary of State to take the evidence on the monetised environmental impacts of the proposal into account when making the decision. Along with the updates to the tag guidance itself, detailed in Dr. Chapman's main proof at pages 6 to 9, this agreement moves the position on substantially from previous airport expansion inquiries, most notably Bristol. In simple terms, when the noise impact is monetised on a conservative basis, the scheme creates a noise cost of around minus 165 million net present value over the assessment period. This is plainly a significant cost, which on its own reduces the benefit of the scheme from 371 million to 206 million. When the carbon impact is monetised, the unmitigated carbon cost, excluding non-CO2 impacts, is minus 134 million over the assessment period. Again, a significant cost. When non-traded climate impacts are accounted for, in this case non-CO2 impacts, the scheme NPV turns negative at minus 272 million. When monetised noise impacts and unmitigated carbon impacts are taken into account, the majority, around 80% of the scheme's welfare benefit claimed by the appellant in the need case is removed. It drops from 371 million to 71 million. This significantly reduces an aspect of the benefit relied on heavily by the appellant. even though all parties now agree that it is open to the inspectors and the Secretary of State to take this evidence of the monetised environmental impacts of the proposal into account when making your decision, the appellant has sought to cast doubt on the usefulness of this more extensive WebTag appraisal, specifically the usefulness of the monetised impacts from noise, the key reason for refusal and a central issue at the inquiry. Mr. Bashforth suggested at various points throughout his oral evidence that WebTag was somehow too complicated for planning inspectors or the Secretary of State to take its outputs into account in decision making, that Haycan East was suggesting the introduction of some sort of alternative planning balance, and that Dr. Chapman's inclusion of monetised noise impacts in his assessment of the overall economic value of the appeal proposal introduced an element of double counting. None of these assertions are credible. Planning inspectors and ministers are well used to considering a range of highly complex and technical outputs from the environmental impact assessment process as part of their consideration of whether developments should be permitted. The monetised outputs from the WebTag Aviation Unit are no more complicated than any other technical data set that an inspector might find it useful to take into account. To suggest that WebTag appraisal is uniquely complex or difficult to understand is simply smoke and mirrors. Regarding the repeated suggestion that Dr. Chapman has attempted to introduce an alternative planning balance, this too smacks of misdirection. It has obviously never been any part of Haycan East's case that WebTag should be used for assessing the noise or the carbon impacts of the scheme as noise or carbon impacts. Rather, it provides an appropriate framework for assessing the impacts of these societal harms on the overall economic impact of the scheme. It would be nonsense to suggest that WebTag appraisal should replace EIA for the assessment of, for example, significant noise effects, and neither Dr. Chapman nor Haycan East as a whole has ever suggested it. Insofar as the appellant has sought to present our case in this way, it is a misrepresentation. Mr. Bashforth accepted as a matter of general principle in cross-examination that non-compliance with the development plan policy is a harm in the planning balance in and of itself and does not prevent the factors giving rise to that non-compliance from also being material harms due to their impacts out in the real world. He also accepted that employment gains, for example, could be a planning benefit in their own right and also feed into an EIA assessment of beneficial health effects, as they have done in the environmental statement in the present case. Using the outputs of the monetisation process in line with best practice WebTag guidance to fully understand the extent of the economic benefits of the appeal proposal or any other planning intervention is no more double counting than either of these examples. Since the oral economic evidence concluded, Dr. Chapman and Ms. Congdon have both produced updated notes. On the monetisation of carbon impacts, where there had been a disagreement, it emerged that the difference between the parties' calculations was primarily driven by differing approaches to the discount rate, which Ms. Congdon wrongly applied from 2019 and Dr. Chapman correctly applied from 2024. I don't propose to go into all the details on these updated notes now, but suffice to say that Dr. Chapman's figures remain robust and credible for reasons which are made good in detail at paragraph 40 in the written closing statement that's been submitted to the inquiry. To conclude then on the socio-economic impact of the proposal. The projected growth in business passenger numbers is highly unlikely to materialise. Absolute business passenger numbers have never recovered to their 2006 levels in the years since the financial crisis. There is no reason to suppose that they will do so in the aftermath of a further structural shift in the market caused by the COVID-19 pandemic. The appellant's assumptions around displacement are opaque and inconsistent, assuming near total displacement of air traffic and carbon impacts on the one hand, and no displacement of employment on the other. Previous projections around employment growth at London City have failed to materialise. Past trends and optimistic assumptions around displacement mean that the claimed employment benefits of the current appeal proposal are likely to be an overestimate. Far from providing a broad social benefit, the appeal proposal would offer a narrow social benefit to a group of older, wealthier, frequent flyers, while simultaneously exposing residents in one of the most deprived parts of London to a material new source of noise nuisance. And finally, WebTag provides a useful framework for assessing the monetised environmental impacts of the proposal, including the monetised impacts from noise, the key reason for refusal. There is no debate that it is open to the inspectors and the Secretary of State to take the results of this monetisation into consideration, and to do so would be in line with best practice guidance from the Department for Transport. Turning then to noise, Haycan East's case on noise has two main components. First, that the appeal proposal would have a demonstrable adverse impact on people living outside the conventional study area, and that this impact ought to be taken into account as a material planning consideration. And second, that the proposed mitigation offered by new generation aircraft is far from certain, and that large numbers of people living within the study area may therefore be more adversely affected by aircraft noise than predicted by the appellant in the environmental statement. Haycan East also agrees with the London Borough of Newham's primary case that the removal of the Saturday afternoon curfew would have an obvious and substantial adverse impact on residential amenity, which would constitute a significant adverse effect and a material harm in the planning balance. The very wide-ranging effects of noise on residents, both within and without the noise contour area, has been reflected in statements to the inquiry from numerous interested parties throughout this apparently years-long process that we've all been involved with. Local residents have described losing sleep and experiencing increased anxiety, feeling embarrassment when entertaining friends in the garden, closing doors and windows even in warm weather to keep out the noise, having to pause conversations while aircraft are taking off, missing dialogue while watching TV. One resident described spending over £17,700 soundproofing his home. Another, who rented privately, had tried to persuade his landlord to take advantage of the appellant's sound insulation scheme, but his landlord had not taken up the offer, and he was therefore left without any sound insulation. On noise impact outside the average mode contour, as highlighted in the evidence of Mr. Thornley-Taylor and Mr. McFadden for the London Borough of Newham, as well as by Haycan East, it is plain that noise from London City aircraft affects residents living outside the study area. This is reflected in the objections to the appeal proposal received from 1,700 individuals who commented on the original planning application, MPs and councillors representing areas as far afield as Wanstead, and 8 other London boroughs, apart from the London Borough of Newham, a quarter of the total for the capital as a whole. The appellant has repeatedly stressed that national aviation and noise policy does not require the assessment of noise impacts below 51 decibels, and suggested that impacts below this level are therefore irrelevant to the decision on the appeal proposal. This ignores the obvious evidence of widespread annoyance from aircraft noise beyond the 51 decibel contour in the very particular circumstances which pertain to London City. Haycan East accepts that national policy does not require an assessment of impacts below 51 decibels to be carried out as part of the EIA process. However, neither does it prohibit either the inclusion of non-standard metrics as part of the EIA assessment of significant effects, or the consideration of noise impacts below 51 decibels as a material planning consideration. Mr. Greer ultimately accepted in cross-examination that national policy does not prevent the inspectors or the Secretary of State from considering noise impacts at lower levels of exposure. Given the very particular circumstances which pertain to London City, these noise impacts are an obviously material planning consideration. 2 distinctive features of London City's flight paths create a particularly high risk of annoyance from aircraft noise for residents outside the average mode contour, living beneath them. First, as regards the easterly mode arrivals flight path, the long level flight segment means that planes fly at around 2,000 feet for many kilometres above southeast London before they reach the base leg turn and turn northwards and eventually come into land. This shelved segment of the arriving flight path includes elevated outdoor spaces such as the Horniman Gardens, where aircraft noise is especially noticeable. Second, the concentration of London City's flight paths in 2016 has had a clear and lasting impact on annoyance caused by London City aircraft. As Mr. Stewart explained in his proof of evidence, the concentration of the flight paths after the CADAP 1 application was submitted, but before it was allowed on appeal in July 2016, resulted in at least a 4-fold increase in complaints about noise to London City. Although the total number of overflown people fell, the impact on those under the concentrated flight paths increased dramatically. Concentration was a seismic change. People complained about the concentration of the flight paths in 2016, and as been very clear from the statements from interested parties during the inquiry, they're still complaining now. A response which belies the suggestion in some of the appellant's evidence that people are only annoyed by new or additional noise, sources of aircraft noise for 1 or 2 years before becoming habituated. In his oral evidence, Mr. Stewart described a conversation he had had with an MP in South East London who explained that planes now flew down her street. Mr. Greer suggested in cross-examination that residents concerned about new flights on Saturdays should engage in the consultation process for the redesign of flight paths, but that provides no assistance to affected residents at risk of losing their Saturday afternoon respite in the here and now. And on the value of predictable respite, the concentrated nature of the flight paths makes this value for overflown residents all the greater. Mr. Stewart described the high value placed on the Saturday afternoon curfew period to supporters of Haycan East living across and beyond the study area, noting that supporters described planning events specifically for Saturday afternoons to guarantee that they will not be affected by aircraft noise. Mr. Greer and Mr. Bashforth both accepted in cross-examination that while current easterly operations account for only 30% of the year on average, it is an unpredictable 30%. They also accepted the general proposition that there is value in predictable relief from overflight noise. On the importance of complementary metrics when considering the noise effects of the proposal, Mr. Greer drew attention in his evidence to the fact that sonar had concluded that no evidence was found to suggest that any other indicators correlated better with annoyance than the LAEQ 16-hour metric. And Haycan East does not dispute the appropriateness of that metric as the primary one for the assessment of significant noise effects. However, as Mr. Stewart indicated in his evidence, in light of the very particular features of London City and its flight paths, complementary metrics are highly useful in the present case to capture the full impact of the proposed changes. Several representations from interested parties also highlighted the dangers of reliance solely on the conventional metric, highlighting that that's not how they perceive noise on the ground. As Dr. Keith McLean noted in a statement that he gave back in December on behalf of the New Providence Wharf Leaseholders and Residents Association, quote, "A man with his head in an oven and his feet in a freezer is not a comfortable temperature, but he might be found to be so on average." Of particular relevance to London City is the stark disparity in the size and population counts between the average mode and the easterly mode contours. Tables 8.3.17 and 8.3.79 in Appendix 8.3 to the environmental statement show that in 2031, on the development case scenario, the average mode contour is forecast to be 22.7 kilometres squared, while the easterly mode contour is forecast to be 44.1 kilometres squared. Meanwhile, the forecast population count for the average mode contour, including permitted developments, in table 8.3.20 is 302,250 people. That's in 2031 on the development case scenario. For the easterly mode contour, we have an estimate of at least 409,850 people, including permitted developments. But there's a footnote 5 which explains that the permitted development data wasn't available for the entirety of that easterly mode contour area. So that figure is likely to be an underestimate. Thus, the easterly mode contour for London City is forecast to be twice as large as the average mode contour by 2031 in the development case scenario, and to be home to at least 100,000 more people, and probably more than that. The easterly mode contour maps that we've looked at a great deal also provide a stark visual representation of London City's concentrated flight paths and the low-level flight for many kilometres over southeast London, showing an extended C-shaped curve within which residents are exposed to noise impacts above the Lowell threshold during easterly operations. For all of these reasons, it would have been beneficial for London City to factor single mode contours into the assessment of the significance of the noise effects of the appeal proposal. In the absence of such an assessment, it submitted that the data on the single mode contours, which is presented in Chapter 8 and Appendix 8.3 of the environmental statement, and the representations from residents living within those contours should be taken into account as a material consideration. The other two metrics which Mr. Stewart suggested would be useful for the inspectors and the Secretary of State to consider were the N65 contour and the cumulative impact on residents overflown by aircraft from both London City and Heathrow. And Hayhenny suggests that the N65 contour data is especially relevant in a context where the primary concern for residents is about new flights on a Saturday afternoon and the number of new flights on a Saturday afternoon that are likely if the proposal is permitted. Meanwhile, the cumulative effect with Heathrow in combination with London City aircraft was apparent from the many representations of interested parties who talked about being affected by aircraft noise from both airports. On mitigation, the promise of quieter planes has been absolutely central to London City's case. It would also appear that this promise has cut through to members of the local community. Natasha Hart, the CEO of the Newham All-Star Sports Academy, who made a representation in support of the appeal proposal in the first week of the inquiry, was asked by you, Madam, about the potential impact of Saturday afternoon aircraft noise on outdoor recreation. And she stated that she'd attended several meetings when London City first presented the appeal proposal, and that BA had promised to make quieter planes, quote, "So then I thought, why not?" In the summer 2019 edition of London City's newsletter, it was initially claimed that the new generation Embraer aircraft were 14 decibels quieter than the old generation Embraers. The benefits and mitigation statement included a more modest claimed reduction of 3.2 decibels per arrivals and 5.4 decibels for departures. Before interrogating the adequacy of the proposed embedded mitigation, two preliminary points must be addressed. The first concerns the concept of a burden of proof in a planning context, and the second, the difference between absolute and perceived noise levels. Now, I don't propose, Madam, to go into too much detail on the quoted passages from the case of Satnam Millennium Limited and the Secretary of State for Housing, Communities and Local Government. They are set out in more detail at paragraphs 62 and 63 of the written closing statement. But in summary, in this case, Sir Duncan Ouseley dealt with the question of legal and evidential burdens in a planning decision-making context, and he held that while it wasn't appropriate to impose a strict burden of proof or beyond reasonable doubt standard of proof in an inquiry context, that some policies can and do require developers to produce evidence to a standard which meets the objective of showing that a particular adverse effect will not occur or is very unlikely to occur. He endorsed a precautionary approach about where the risk of error should lie, so that the more serious the risk of an adverse effect occurring, the greater the certainty or the degree of precaution required in the applicable evidential standard. In the context of the present appeal, Policy D13 of the London Plan 2021 sets out the agent of change principle, which places the onus for mitigating the impacts of new noise or nuisance generating development on the developer. And Policy T8 Part B provides that, quote, the environmental and health impacts of aviation must be fully acknowledged, and aviation-related development proposals should include mitigation measures that fully meet their external and environmental costs, particularly in respect of noise, air quality, and climate change. At a national level, Making Best Use provides general policy support for airports beyond Heathrow making best use of their existing runways, but provides that as part of any planning application, airports will need to demonstrate how they will mitigate against local environmental issues, taking account of relevant national policies. It also explicitly does not prejudge individual applications or provide carte blanche for expansion where local environmental impacts cannot be satisfactorily mitigated. Thus, case law, national and local policies are agreed that the onus for mitigating the adverse environmental impacts of airport expansion proposals and for providing sufficient evidence to demonstrate the adequacy of that mitigation lies upon the appellant. In the present circumstances, that means that the burden is on London City to demonstrate that the proposed embedded mitigation from new generation aircraft is as effective as claimed, not on Haycan East to prove that it isn't. As for the extent to which any reduction in noise levels is likely to be noticeable or meaningful to residents on the ground, the CAA's webpage on measuring and modelling noise notes that, quote, a change of 3 decibels has been defined as the minimum perceptible under normal conditions, while a change at 10 decibels corresponds to roughly a doubling or halving of loudness. Mr. Greer accepted in cross-examination that 3 decibels was, generally speaking, about the minimum perceptible in normal conditions, though some people might be able to perceive slightly smaller variations. Dr. Knoll's citizen science study found that the difference between the old and new generation Embraer aircraft from his 6 monitoring stations within the easterly mode contour but outside the average mode contour was around 1.7 decibels on average. He also found that there was considerable variation between individual aircraft, with occasional reports from citizen researchers of very loud whistling whale-like noises from the Airbus A220-100 aircraft, and that the new generation of planes were not meaningfully quieter on average during overflight than older aircraft. During his oral evidence, Dr. Knoll addressed the results of the Bickerdike-Allen study carried out using Class 1 sound level meters and published by London City in November of last year. And he explained how they intersected with the findings of the citizen science study. In particular, he highlighted that from the Lambeth monitoring site in the new study, a difference of 1.9 decibels was recorded between the Embraer E190 and E190-E2 on average. This is very close to the 1.7 decibels that he found for the same aircraft. And like his monitoring sites, the Lambeth site in the Bickerdale-Allen study lies outside of the average mode contour, but within the easterly mode contour. So they're comparable sites in that respect. Thus, the results of the new survey serve to validate Dr. Knoll's results for the 2 generations of Embraer aircraft and increase the confidence that you, the inspectors, and the Secretary of State can place on his other findings. For example, concerning the variation between different models of aircraft which were measured from the same monitoring sites. Contrary to the suggestion by Mr. Greer that this variation was in some way abnormal or that it undermined Dr. Knoll's findings, we can see from other empirical studies cited in the citizen science study paper that in fact this is entirely consistent with real-world data sets from across Europe measuring aircraft noise. In section 5.4 of the citizen science study, Dr. Nold addresses the, quote, notable discrepancies in decibel measurements of the same aircraft. And he notes that this is in line with other empirical studies, such as Simmons and colleagues, who identify that variability in noise levels for flyovers of the same aircraft type can be as large as 12 decibels, hampering noise assessment around airports. The study proposes that variable atmospheric effects, the variable atmosphere affects the acoustic propagation, and variations in the aircraft emitted noise are the two main contributors to this variability. And the Simmons et al. Paper is included in the core documents list, and it argues that most of the noise variability that we see in these real-world studies is due to thrust settings, and concludes that to solve at least part of the airport noise assessment problem related to the large noise level variation observed for flyovers of the same aircraft type, it's concluded that it is necessary to incorporate a more accurate engine setting of the aircraft into models for noise contour calculations around airports. So this discrepancy between real-world data and modelling is not something that's unique to Dr. Nold's study. It's something that can be seen across Europe in other similar studies of this kind. And thus, these measurement variations are expected in on-the-ground data sets recording noise levels from aircraft during overflight. Far from undermining the credibility of the study, the 13 decibel variation that Dr. Nold found illustrates one of its central findings, that on-the-ground measurements from new generation aircraft demonstrate great variability even within the shelved and supposedly stable part of the flight path, which is obscured by the use of averaged metrics and modeled data. Haykanis suggests that the variation in absolute noise levels identified in the citizen science study provides a valuable illustration of a crucial point, namely that there is a high degree of uncertainty around the noise impact that any single aircraft will make at a specific place and time. And it should also be noted just briefly on this point that the data that Mr. Greer pointed to in table 4 of the citizen science study was comparing measurements at the quietest and the loudest locations, since measurement locations such as the Horniman Gardens, for example, elevated, and thus would be likely to experience louder overflights. And if we look at the aircraft comparison between the two Embraer aircraft at each separate location, there's actually very little variability in the difference found between the two generations of Embraer aircraft. The extent of that variation is very much in line with Dr. Nold's overall 1.7 decibel figure. Overall, therefore, while the absolute measurements vary quite considerably, the relative comparison between the two aircraft is very close for each location. The new Bickerdike-Allen study records data from London City's fixed noise monitoring terminals, and that data showed was much closer to the claimed figures in the benefits and mitigation statement. They found a 3.4 decibel improvement in the new generation aircraft for arrivals at Noise Monitoring Terminal 5, which is situated within the 57 decibel contour. And as noted previously, all of the sort of modelled locations that are included as the point-specific data in the environmental statement are situated also within the 57 decibel contour. So this leaves us in a position where we know what's happening within the 57 decibel contour, where there is likely to be a modest but meaningful improvement in noise levels from the new generation aircraft. And we know what is happening outside the average mode contour in that long C-shaped tail of the easterly mode contour, where the difference is likely to be imperceptible. However, between the two, there is a band of uncertainty, or what Dr. Nold referred to as the Here Be Dragons area, where we simply don't know what's going on. It's far from clear how quickly the perceptible benefits from new generation aircraft recorded at Noise Monitoring Terminal 5 drop off, since no empirical data for the 51 decibel contour or the 54 decibel contour is before the inquiry. Analysis of the data presented in table 8.3.20 of the environmental statement, which shows summer day population counts, including permitted development, shows why this band of uncertainty is so significant. And I asked Mr. Greer in cross-examination, and he confirmed that the figures in this relevant table are cumulative. So the number of people that are predicted to live within each 3 decibel contour band can be obtained by subtracting the next figure down in the table, essentially. And when we do that, we can see that around 130,400 people are forecast to experience noise impacts between 51 decibels and 53.9 decibels by 2031. And that represents 44% of the total population who live within the Lowell, but outside of the Sol. 90,800 are forecast to experience impacts between 54 decibels and 56.9 decibels, and that is a further 31% of that total Lowell to Sol population. So altogether, around 3/4 of all of the people who live within the Lowell threshold, but outside the Sol threshold, are concentrated in the outermost portion of the study area. And those are the blue bands that we see on the contour maps, the light blue and the dark blue bands. If the reduction in noise levels from the new generation aircraft within the 51 decibel and 54 decibel contours is closer to the 1.9 decibels measured at Lambeth and the 1.7 decibels measured by Dr. Knowles than it is to the 3.4 decibels measured at Noise Monitoring Terminal 5, then 3/4 of the people living between the Lowell and the Sol thresholds may be subject to considerably more adverse noise effects than predicted. This uncertainty could easily have been avoided if Bickerdike Allen, on behalf of London City, had carried out additional noise monitoring within the 51 decibel and 54 decibel contours. But such monitoring either has not been carried out or at least has not been provided to the inquiry. And on this point, it's important to correct a misrepresentation of our case, which arose during re-examination, first of Mr. Greer and then of Mr. Bashforth. And in the appellant's opening statement, they recognised at paras 78 to 79 that the concepts of Lowell and Sol introduced by the Noise Policy Statement for England do not in themselves equate to findings of significance in EIA terms, that the assessment of air noise impacts in the context of EIA has regard both to the absolute level of noise and the difference in noise levels between the development case and the do minimum scenario. And this is an important point because it highlights that significant effects in EIA terms are not confined to the area above the Sol threshold. That is, even though it's called the significant observed adverse effect level, we're not only concerned with the baseline, we're also concerned with the magnitude of the change. And it's possible for there to be a significant effect if people within the Lowell are exposed to a significantly large change. Hayken East has not disputed the appellant's estimate of the likely level of change for people living within the Sol, and therefore the probability of significant effect on these people in EIA terms, we don't dispute. It's supported by the empirical measurements for the new generation aircraft from London City's fixed noise monitoring terminals, demonstrating that they do provide the claimed level of reduction from the benefits mitigation statement when the measurements are taken close to the runway. What is disputed is the effect of the proposed development on people living within the Lowell. As set out, the evidence from our citizen science study, validated by the almost identical findings from the Bickerdike Allen survey, is that the new generation Embraer aircraft provide such a small reduction in noise levels during overflight that most people wouldn't be able to perceive it in normal conditions. Yet no on-the-ground measurements have been taken within the 51 decibel, 54 decibel average mode contours, those light and dark blue portions of the noise contour maps, to see whether the benefits are actually felt across the study area. And therefore, contrary to the suggestion put to Mr. Bashforth by Mr. Humphreys in re-examination, Hayken East's case has never been about how far out the orange extends on the noise contour maps. It has always been about how big is the impact being felt on the ground by the vast majority of affected residents living within the blue area. A few brief points on the compensatory mitigation that is proposed by the airport. which is proposed to accompany and to mitigate the removal of the Saturday curfew, such as the enhanced sound insulation scheme. These are subject to some important limitations. First, they're only available within the 57 decibel contour. Outside that contour, where, as we've just heard, the bulk of the residents within the Lowell live, individual residents would still be required to pay for any sound insulation measures, and potentially, as we heard from that resident on the first afternoon, at great personal expense. Second, the sound insulation scheme doesn't provide any benefit for private tenants unless their landlords are willing to apply to London City for financial assistance. And if the landlord doesn't consent to having the work done, then the tenant can't benefit from the scheme. There's a high proportion of private renters in London. That's likely to be a fairly common problem. And third, the sound insulation scheme provides no benefit when residents are outdoors. Mr. Greer's point about the amount of time that people spend indoors versus outdoors on average misses the subjective value of time spent outdoors in urban green space for health and well-being and general quality of life. And all of that is set out in the short rebuttal proof of Mr. Stewart. Turning finally then to planning and the development plan. Broadly, Hay-Can East agrees with the London Borough of Newham that policies SP2 and SP8 of the Newham Plan are both relevant to the determination of the appeal, and that they should be interpreted to encompass impacts from noise on residential amenity and well-being, broadly construed, rather than as being focused narrowly on health impacts alone. Policy SP2 requires development to attend to the environmental impacts of noise as a contributor to health and well-being. And there's nothing in the text of that policy to suggest that it applies only where an adverse health effect has been formally identified as part of the EIA process. Similarly, policy SP8 refers to the need to avoid unacceptable exposure to noise as an amenity or health impacting pollutant. So again, there's clearly an amenity component to the policy. On policy T8 and climate change, Hay-Can East notes that policy T8B requires proposals for aviation expansion to include mitigation measures that fully meet their external and environmental costs, particularly in respect of climate change, and that any airport expansion scheme must be appropriately assessed and, if required, demonstrate that there is an overriding public interest or no suitable alternative solution with fewer environmental impacts. And the explanatory text at 10.8.8 provides that the aviation impacts on climate change must be fully recognised and emissions from aviation activities must be compatible with national and international obligations to tackle climate change. The implications for other sectors and other airports must also be fully understood when expansion proposals are brought forward, and aviation greenhouse gas emissions must be aligned with the Mayor's carbon reduction targets. In the case of the Crown on the application of Cherkley Campaign and Mole Valley District Council, the Court of Appeal laid down some principles for the interpretation of explanatory text. And they held that, amongst other things, when determining the conformity of a proposed development with a local plan, the correct focus is on the plan's detailed policies, that the supporting text is relevant to the interpretation of the policy to which it relates. It's not the policy or a part of the policy. It doesn't have the force of policy, and a failure to satisfy an additional criteria referred only in the supporting text doesn't constitute a failure to comply with the development plan, provided that the proposal conforms with the text of the plan policies. And that applies even where the local plan states that the supporting text indicates how those policies will be implemented. In New Dawn Homes and the Secretary of State for Communities and Local Government, these principles were sort of summarised shortly by Mr. Justice Holgate as follows, quote, "The reason justification can affect the correct interpretation of a requirement contained in the policy, but it cannot impose an additional requirement outwith the policy itself." However, Mr. Justice Holgate further held that a piece of explanatory text may still be relevant to the interpretation of the policy, even if In and of itself, it crosses the line into inserting an additional policy requirement. That requirement won't be enforceable, but the text may still perform an important interpretive function of what is in the policy. And just to note very briefly that Mr. Bashforth in his proof at paragraph 311 also referred to another aspect of the explanatory text for this policy, which performed accepted in cross-examination that it performed a useful function in helping him to interpret the meaning of the policy. There was disagreement between the planning witnesses over what the reference to the mayor's carbon reduction targets in the explanatory text referred to, and it was suggested by Mr. Bashforth that it referred back to the overall statutory net zero 2050 target in London Plan Policy GG6. However, the explanatory text at paragraph 10.8.8 contains no cross-reference to policy GG6, nor does it specify any particular carbon reduction target. Mr. Farmer's interpretation of this text was that it was sufficiently general that it could refer to any carbon reduction targets set by the mayor, which would encompass the 2030 net zero target. This is the more credible interpretation of the explanatory text. In January 2022, the mayor set out details of how he intended to meet the target of making London net zero by 2030, a promise which had formed part of his re-election campaign. And he did that in the policy paper London Net Zero 2030, an updated pathway. This document draws on a report commissioned for the mayor and published on the 18th of January 2022 by Element Energy, Pathways to Net Zero Carbon by 2030. The report concluded that regardless of which of the proposed potential pathways to net zero the mayor ultimately adopted, quote, aviation emissions have a large impact on the level of residual emissions from transport. As such, limiting growth of aviation as far as possible is a crucial action for achieving the mayor's climate ambitions, unquote. The appellant has sought to dismiss the updated pathway document in evidence as merely a starting point for consultation. However, while it certainly does contain consultative elements, it's clear that what is being consulted upon is methods of achieving the 2030 target and not whether that target should be adopted at all. The explanatory text at 10.8.8 requires expansion proposals to be aligned with the mayor's carbon reduction targets. While this text cannot introduce a strict requirement not found in the text of the statutory policy, it can perform an important interpretive function. Moreover, the updated pathway document is capable of being a material planning consideration in its own right, as set out in Mr. Farmer's proof of evidence at page 16. In the present circumstances, it is the text of the detailed policy itself which sets out what this alignment with the mayor's carbon reduction targets means in practice, namely that, subject to an appropriate assessment, proposals must demonstrate that there is an overriding public interest or no alternative solution with fewer environmental impacts. Turning to the issue of compliance with the development plan as a whole. Haycan East agrees with the London Borough of Newham that the appeal proposal fails to comply with the well-being and quality of life aspects of policies SP2 and SP8 of the Newham Plan, due to the failure to provide adequate mitigation for the significant adverse effect on noise arising from the removal of the Saturday afternoon curfew. The appellant has repeatedly stressed the emphasis in policy SP2 on the need to improve employment levels and reduce poverty. For the reasons set out by Haycan East in its socioeconomic evidence, the extent to which the appeal proposal can be expected to do either of these things is highly uncertain. Haycan East also agrees with the London Borough of Newham that policies D13 and T8 of the London Plan are breached on grounds of noise, since the inadequacy of the proposed mitigation for the noise impacts of the appeal proposal means that it fails to clearly demonstrate how noise and other nuisances will be mitigated and managed in accordance with policy D13, or include mitigation measures that fully meet its external and environmental costs, particularly in respect of noise, in accordance with policy T8. In addition to breaching policy T8 on grounds of noise, Haycan East submits that an additional conflict with the policy arises in respect of the appeal proposal's climate change impacts. In her note, submitted in response to Dr. Chapman's additional note, Ms. Congdon accepted the point made by Dr. Smith that air travel from London City is less efficient than travel from alternative airports by a factor of 60%, and overall emissions would therefore be lower if passengers were to fly from other London airports operating larger aircraft. Even in the context of near total displacement, this means that there is still a carbon cost to the scheme. Policy T8 requires that the demonstration of an overriding public interest or lack of suitable alternatives. In circumstances where the appellant has provided, to adopt Mr. McFadden's phrase, a business case rather than a need case, and where there would be an acknowledged lower climate impact if additional demand was handled at other airports, the appeal proposal satisfies neither of these criteria. On the planning balance, the appeal scheme conflicts with policies SP2 and SP8 of the Newham Plan and D13 and T8 of the London Plan, and therefore the development plan taken as a whole. Accordingly, the presumption against the grant of planning permission under Section 38(6) of the Planning and Compulsory Purchase Act 2004 comes into play. Permission should be refused unless material considerations indicate otherwise. Turning to the benefits claimed by the appellant, HACAN East recognises that there will be some economic benefit from the appeal proposal, at least provided that non-CO2 climate impacts are excluded from the calculation. But the extent of this benefit has been greatly overestimated for the reasons set out in the evidence of Dr. Chapman and the economics section of this final closing statement. Specifically, the employment gains from the proposal are likely to be less than predicted, business passenger growth and consequently GDP growth lower than forecast, and the monetized environmental harms arising from the proposal to be substantial. All of these factors greatly reduce the weight that can be attributed to the economic benefits in the planning balance. The claimed beneficial effect on health is also predicated on assumptions about employment and noise that are disputed by HACAN East. While no issues taken with the methodology of the health chapter in the environmental statement, if the inputs are wrong, the outputs will be wrong. And HACAN East therefore contends that there's a considerable uncertainty about the health impacts of the proposal. Contrary to paragraph 9.4.4 of Mr. Bashforth's proof, they cannot be safely attributed positive weight in the planning balance. For all of the reasons set out above and for all of the reasons set out here, the embedded noise mitigation is extremely uncertain regarding the level of reduction in noise levels for residents within the 51 decibel and 54 decibel contours. This reduces the weight that could be attributed to the benefits of faster refleeting if the appeal proposal is granted permission. National aviation policy does provide support for aviation expansion in general terms. However, making best use weighs negative in the planning balance where there is non-compliance. And as HACAN East has contended, in circumstances of the current appeal, the appellant has not demonstrated that the adverse environmental impacts will be satisfactorily mitigated, and therefore the policy support of NBU does not apply. The projected greenhouse gas emissions from the airport in the year 2031 on the development case scenario will be 389,519 tonnes of carbon dioxide equivalent, and that's a net increase of over 77,000 tonnes over the do minimum scenario. Nevertheless, London City has suggested that the appeal proposal will actually have a positive effect on climate change because it will purportedly facilitate this new generation of planes with lower per passenger emissions. In light of the acknowledged higher carbon costs of meeting new passenger demand at London City, rather than other larger airports serving London, it is illogical for the appellant to suggest that the carbon impacts of faster refleeting should be awarded any positive weight in the planning balance. Turning finally to harms, the key harm is, of course, the adverse impact on residential amenity within the study area, arising from the removal of the Saturday curfew. as set out by the London Borough of Newham in its evidence, assessing the extent of this harm will require an element of subjective planning judgment on the part of you, the inspectors, and the Secretary of State. But Hay Kenny's contend that it will be a significant and that great weight should be attributed to it. Hay Kenny's also submits that the widespread evidence noise impact outside the 51 decibel average mode contour is a further material harm which weighs against the grant of permission, as is the uncertainty around the embedded mitigation, which affects the reliance that can be safely placed on the assessment of the noise effects within the LOL in the environmental statement and Mr. Greer's proof. Though Mr. Bashforth, of course, took a different view on the substance of the noise and economic evidence, he accepted that if the inspectors and the Secretary of State were to accept Hay Ken East's evidence on the extent of the economic benefits of the proposal and the uncertainty on the proposed embedded mitigation, this would feed through into the weight that could be attributed to those benefits and harms, respectively, in the planning balance. The acknowledged greater climate change impact of the proposal than if additional demand was handled at larger London airports is a further harm of the proposal. Accordingly, on balance, while there are material considerations which point towards the grant of planning permission, these do not overcome the presumption against as a result of lack of compliance with the development plan, taking into consideration the material considerations that weigh against the grant of permission. The strength and scale of local opposition to this appeal proposal has been apparent throughout the process. In circumstances where there is a considerable risk of environmental harm and uncertainty over its likely extent, a precautionary approach should be adopted. In the present circumstances, we have hundreds of thousands of people who will be exposed to a material new source of noise on Saturday afternoons, and given the uncertainty over the proposed mitigation, tens of thousands who may be exposed to more significant adverse effects in EIA terms than forecast by the appellant. In line with the precautionary approach and local planning policies, the burden is on the appellant to demonstrate that adverse environmental effects will not occur or are very unlikely to occur. This burden has not been discharged. Set against this risk of significant harm, we have economic benefits which have been shown to be highly speculative, and the inspectors are thus invited to recommend to the Secretary of State that the appeal be dismissed. Thank you very much.
Thank you very much, Dr. Lane. And obviously, I know Ms. Dahan isn't with you, but obviously, you know, thank you to her as well. So thank you, everyone. We will have a break now. We'll resume at 2 o'clock, where we'll hear the final closing from the airport. Thank you very much, everyone. Thank you. Okay, yeah, welcome back. I see we're zooming in gradually to Mr. Humphreys.
They seem to be speaking.
To have audio from you, Mr. Humphreys. I'm not sure if that's.
You turn up volume.
Sorry, we just
Again, the technology at the last hurdle. It's been one of those inquiries.
Exactly. What you haven't noticed clearly is
Still can't hear you.
the speaker is gaffer taped to the ceiling here.
Not sure.
Just we wanted it to feel familiar.
I presume everyone else can hear me.
I can hear you. Can you hear me?
I can hear you, Inspector Searson, and I can hear Mr. Humphreys.
I can't hear you, Inspector Ayres.
Maybe try rejoining. Have you joined with your audio? Have you? It doesn't say you're on mute.
Not my speak. Can everyone hear me? Yes. Okay. I can't hear anyone. So it's not my speakers. I'll come out the meeting and come back in. So just bear with me. I do apologise for this. Okay.
Slightly tilted. I think the entire room is slightly tilted. If you look at the mantelpiece. Slide off side.
It looks like you've got that Friday afternoon feeling, Mr. Humphreys, where...
Yeah, except as you know, I have it from Monday morning through the whole week.
Inspector Searson, have we got you back? Can you hear us now? I fear that's a no. I can't hear you, Inspector Searson. Your speakers for some reason aren't working. And you can't hear me. Right. I'm going to adjourn for 10 minutes and contact Inspector Searson offline and have a conversation. So if everybody could come back well, for 5 minutes, if everybody come back at 2:10, then I will contact Inspector Searson and find out what's going on. All right. Thank you.
I don't know if anyone's listening as a test, but if anyone could just say they can hear me, that would be very helpful.
Yep, I can hear you.
Ah,
Yeah,
thank you, Mr. McCallum. Hurrah, I can hear you as well.
Okay.
I understand we're actually coming back at 10 past now, but I think I'll leave my computer on for fear of it collapsing again. So I'll stay here and on. But
No problem.
okay, yeah. Hopefully people can hear me and I can hear them. Apologies for that.
That was all in the finest traditions of this inquiry, surely.
Oh, absolutely. And you wouldn't believe I'm actually in a hotel conference centre as well. So there's an irony there, I think. But apologies, Mr. Humphrey, for the slight delay.
Not at all.
So if you want to proceed with the closings for the airport, we're in your hands. Thank you.
Thank you. Thank you, madam. Thank you, madams. Now, clearly, our closing submissions, as you will see from the download, are long, some 78 pages with over 430 footnotes. That's the bad news. The good news is that I won't read them. But what I will do is take you through. I'll summarize large sections and just point to where we've covered things, and then I'll read bits as appropriate. But it just seems to me that on a Friday afternoon, in a context where you're going to read the written submissions anyway, there's little point me just trying to read everything. I'll just sort of read the first few paragraphs by way of introduction, and then I'll sort of take you through things. So, madam, the introduction is airports and airport expansion play a critical role in boosting both global and domestic connectivity and levelling up the UK. National policy recognises the role of airports as engines of economic growth, supporting trade, inward investment, tourism, economic prosperity, and significant numbers of jobs. And it is for this reason that government policy remains supportive of airports bringing forward expansion plans in order to make best use of their existing infrastructure. It is in this context that London City Airport seeks to amend certain conditions that currently limit its operations. And these amendments will have a substantial positive socioeconomic impact on the local area. This translates into real-world benefits for real people, opportunities for skills training, jobs, the chance to travel from their local airport, increased economic activity in their local area, and further investment in the place that they live and work. And these benefits are particularly important in the context of the local area around London City Airport. And the airport sits in the heart of the Royal Docks and Beckton Riverside opportunity area, one of the largest opportunity areas in London. The area has been identified to provide some 30,000 new homes and 41,500 new jobs over the next 20 years. The airport is recognised as a, quote, anchor economic asset of regional and international importance, and a key local employer and a catalyst for investment within the area. In 2019, the airport employed 2,310 on site and generated another 850 jobs within the local area, or 1,370 across London, through its supply chain and induced effects. The local plan policy supports the optimization of existing capacity at the airport, alongside a further mitigation of its environmental impacts. The importance of job creation for the local area is significant. Parts of East London are recognised as some of the most deprived in the UK. The identification of East London as a priority area for levelling up is largely driven by unemployment and a lack of jobs. The proposed amendments represent a significant opportunity for the local area and could play a role in putting Newham back on the map. The proposed amendments will allow the airport to recover from the effects of the COVID-19 pandemic. And in doing so, it will create the conditions in which there is a strong incentive for airlines to refleet, thereby delivering real noise benefits throughout the week. This will support the airport's recovery whilst bringing significant economic, consumer and other benefits. Before going on to consider the airport's positive case for the proposed amendments and the issues in dispute, it's important to deal with some preliminary points, and I'm going to come on and summarise some of those in a moment. What I've just put there in the next couple of sentences, in the footnotes, we've tried to direct you where there were things that came up in evidence in chief or cross-examination, things like that, to the relevant day, because slightly unusually, this inquiry has had so many sort of misstart days. In the footnote, we've put what we have counted as the days. So, for example, day 4, Monday the 15th, even though actually all that we achieved on that day was putting up gaffer tape. But we've tried to do that so that you're not kind of misdirected. So I hope that's useful. But that footnote 12 is kind of important. So the preliminary points, context and nature of the application. So I've set out there in the paragraphs that follow paragraph 7, the planning context, the conditions that we're seeking to amend and so on. From paragraph 11, I've dealt with the proposed amendments and that they would facilitate various changes. In paragraph 15 and following, I've dealt very light touch with those points that the London Borough of Newham have made about the nature of section 73 and the conditions and what you're able to look at and so on. I don't need to actually read through all of that. From paragraph 20, I've dealt with the development of and the rationale for the proposed amendments, and that continues then on for a while. All of this text is important, Madam. I'm just trying to, summarize things. What I'm going to try and focus on is those elements of the case where there's a direct issue between the parties, particularly on the forecasting and the need and the policy, and perhaps talk through some of that, but that's not to suggest that all this other stuff isn't important too. So paragraph 31 turns to the scope of the dispute, and paragraph 33 is in a sense, I hope helpful, that we've set out there that what is not in dispute. And to be perfectly honest, there's a huge amount in this case, perhaps unusually for an airport case, there's an absolutely huge amount that is not in dispute. And it's one of the features of this case, contrast with many other large infrastructure projects and in particular airport projects where many things are in dispute. Actually, it's all pretty narrow. The noise point is a pretty narrow point, and so are the others. So we've identified there what the areas of broad agreement are. And paragraph 36, there we've identified the four main sort of areas where there are issues: the air traffic forecasting, the socioeconomics, the noise, and then planning policy. And first we deal with air traffic forecasting. And I'll read through some of this, particularly the points about the definition of need, because that was something that perhaps needs to be explained. So paragraph 37, the primary role of air traffic forecasting in the context of this appeal is to establish the demand and thereby need for growth in capacity and extended operational flexibility at the airport, and to produce the inputs to the environmental impact assessment of the development. And that's kind of quite an important point, because what the forecasts do is provide that input to the impacts, and it's the impacts which are, the focus of the reasons for refusal, and it's quite important to actually keep that in mind. What the air traffic forecasts are there for. The air traffic forecasts also enable an understanding of how the proposed amendments will allow growth in passenger throughput at the airport and facilitate socioeconomic and other benefits. And the forecasting of Ms. Congdon in her evidence also demonstrates the relationship between the proposed amendments and the rate of refleeting at the airport, which is obviously an important issue. So I just touch on the definition of need to set out how we characterize that. Whilst not an issue raised by the council in its statement of case or its written evidence, during the course of the inquiry, it became apparent that a key matter in dispute was the meaning of the term need in the context of this appeal, and the extent to which it is necessary for the airport to demonstrate a particular need for the proposed amendments. In particular, Mr. Straker Casey's cross-examination of all three airport witnesses advanced the following lines of argument: that the need advanced in the airport's case is merely a business need on behalf of airlines. Secondly, that there is no demonstrable need for the proposed amendments in circumstances where there is no evidence that either the airport or the airlines would be unviable without the proposed amendments. And thirdly, that there is no evidence before the inquiry of a particular need from local people for Saturday afternoon flying. There are 4 points to make in response as follows. First, as a matter of principle, it's not necessary for airports to demonstrate a particular need for their expansion proposals. As explained by Mr. Bashforth, national aviation policy provides very strong in-principle support for meeting demand for air passenger travel where it exists. It is for this reason that the airport's need case, in common with the need cases produced in every other recent airport expansion proposal, has focused on demonstrating that demand exists in the catchment for the airport and how its proposals will meet such demand. Second, the approach adopted by the airport in its needs case is supported by the approach taken in other recent airport appeal decisions, in particular the issue of whether a specific need must be demonstrated for airport development proposals was directly considered in the Stansted appeal in May 2021. In that decision, the panel of inspectors explained that in the context of making best use policy, quote, there is no requirement flowing from national aviation policy for individual planning applications for developments at MBU airports to demonstrate need for their proposed development or for associated additional flights and passenger movements. In a similar vein, the Secretary of State in the Manston appeal decision found that MBU policy does not limit the number of MBU airport developments that might be granted and does not include a cap on any associated increase in air transport movements as a result of intensifying use at MBU airports developments. Finally, the panel of inspectors in the Bristol appeal decision found that there was a clear and compelling need for the development as evidenced by the UK's aviation forecast and reflected in the policy support for MBU, and that Bristol Airport Limited's forecast was sufficiently robust. So as explained by Mr. Bashforth, these recent appeals also demonstrate that there is no policy support for suggesting, as LBN has, that the airport should not be allowed to expand on the basis that there is existing capacity at other London airports. Third, the interpretation of need as being linked to the viability of airlines or the airports as a whole represents a significant departure from the approach adopted by Mr. McFadden, who was at that time the case officer in the officer's report. The analysis in the officer's report specifically considered the need case on behalf of the airport and, drawing on Dr. Smith's advice, concluded that it was not disagreed with. The report considered the demand forecast produced by York Aviation and considered that whilst there remained elements of dispute between LBN and the airport, LBN was satisfied that growth was expected and that the proposed amendments could meet that growth. It was on this basis that the officer's report concluded that it's acknowledged that the expansion of flights into Saturday afternoon would enable the airport to make more efficient use of existing infrastructure and runways. The approach to need adopted by Mr. McFadden in the officer's report was appropriately informed by government's policy of making best use and the airport's aviation demand forecasts. The officer's report made no reference to the viability of the airport or individual airlines. It was plainly right not to do so. And it's no part of government policy that airports can only expand if such expansion is necessary to prevent their businesses or that of airlines becoming unviable. Indeed, government policy supports the creation of a competitive aviation industry and the delivery of consumer benefits, which relies upon the aviation industry being economically strong. Fourth, with regard to the argument that there is no demonstrable need from local people to fly on Saturday afternoons that could not be met during the week, this fundamentally misunderstands the nature of the airport's demand forecast. As explained by Ms. Congdon, the demand forecast is based on national forecast growth in aviation demand, of which the airport will meet a proportion. The forecasts demonstrate a demand for leisure travel throughout the week, including at weekends. The starting point in the context of MBU is that demand should be met. In order to meet the demand for leisure travel, conditions must be created at the airport where airlines can viably operate such services. This includes permitting operations at times that the demand for the business travel is less, as well as reducing the current inefficiency in aircraft utilization. The question is not, therefore, whether an individual passenger who might prefer to fly on a Saturday afternoon could instead travel on a weekday. Such an approach would be to deny consumers choice of where and when they want to fly from. This is directly contrary to government policy in Flight Path to the Future, which makes clear that consumers are at the heart of UK aviation, and ensuring that the sector continues to deliver effectively for all consumers will be essential for its future success. It is notable that LBN's case that there is no evidence of demand for Saturday afternoon flying is inconsistent with its position in respect of Saturday afternoon noise effects, which is predicated on an assumption that there will be flights during this period. There is no obvious reason why airlines would put on flights during a period where there is no demand. Such circumstances, the noise effects about which the council are concerned would simply not arise. In short, meeting the clear demand to fly from the airport in accordance with MBU is need for the purposes of this appeal. So then what I've done here is in paragraph 49, just identify, again, a number of points in relation to forecasting that are agreed. Don't need to read through all of that. And then from paragraph 51 onwards, I've set out the policy context. That is important. It is actually very important, but I'm not going to read it all out. Clearly, a lot of it is Madam quotes. I know you're very familiar with those things, but we thought in the context where you told us that you wanted the submissions to, in effect, set out the positive case so that, you know, this can be adopted or adapted in your reporting, that's precisely what we've done. So this is a section which summarises much of the relevant policy in relation to forecasting. From paragraph 63 onwards, there's some text on the wider context. Some things there relating to the drivers of air traffic demand, the particular context of London City Airport and its proportion of business passengers and so on. Draw attention to, but I won't read it all, but footnote, for example, 122. It's a point in effect that Hakan were making about a portion of business passengers, and yet this, they say wrongly, is inconsistent with the emphasis on leisure, and that's completely wrong and a misunderstanding. And Ms. Condon did explain that, and the footnote just deals with that point. The next main subheading there, London City Airport's air traffic forecast, again, is setting out this positive case. And I don't think I need to read this. The first subheading, though, is forecasting methodology, and we describe that. From paragraph 69 onwards, we deal with managing uncertainty, because in many airport inquiries, certainly in the past, uncertainty was always an issue. And you know, Madam, we've tried to deal with uncertainty in two ways. Firstly, internally within the York Aviation modelling approach, which uses the Monte Carlo approach. So, you know, it takes a central position, but it also then looks at extremes, and it then, in effect, blends different types of extremes to come up with an overall sort of fan of probability. But the second, and this is important, is the sort of faster and slower growth cases, and the use of that type of approach is relatively new, and again reflects the type of approach used by the Airport Commission when they looked at, you know, what are the extremes. But the idea is, look, if we are capped at 9 million passengers per annum, we know that is a cap, that is a fixed sum. That figure might be arrived at slightly earlier than we forecast or slightly later than we forecast, but at the end of the day, whether earlier or later, it's still a 9 million passenger per annum airport. And the point of looking at that is, does it make a difference to the environmental effects? Is there some, as I sometimes call it, cliff edge that you fall off, that actually if you're 3 years earlier, the effects are radically different from the core forecast, or if it's 3 years later, are they radically different? And the answer is no. They're pretty similar. And so the use of faster and slower growth, and then the taking of that into account in environmental impact, assessment allows you to have confidence that even if there is some short-term uncertainty in terms of forecasting, it doesn't have a material effect on the environmental effects. So paragraph 73 looks at forecast scenarios. From 75 looks at the nature of air traffic forecasts, and from 77, the point you raised, Madam, on split decision, and maybe I'll just kind of read through paragraph 78 just to sort of give you what our take is on this. During the inquiry, Madam, you raised the point about a split decision, i.e. whether there could be a grant of planning permission amending the other conditions, but retaining the existing limits on weekend operations in what's now condition 17. And clearly, obviously, section 73 does allow some conditions to be amended and not others. That's not in dispute. That's not the issue. The issue is whether by splitting the decision, different benefits and environmental impacts of the development would have been properly assessed. The airport's position is expressed, in fact, by me during the inquiry, is that the extension of the hours on Saturday afternoon is fundamental to meeting the need, driving the socioeconomic benefits of the proposal, and also through its agreed acceleration of refleeting, it's also fundamental to the overall noise benefits. And as the effects both positive and negative of granting section 73 permission without amending condition 17 to extend the hours has not been assessed, the airport is concerned that any such decision might be susceptible to legal challenge, and that's the view I expressed to you during the course of the inquiry, and that's still our position, that we would be concerned about that, and that Secretary of State should be concerned about that. Paragraph 79 deals with refleeting, and that's a topic you'll be familiar with. In paragraph 80, we do draw attention to the BA City Flyer letter, which is appended to Ms. Congdon's evidence. That is an important statement from one of the principal airlines and a home-based airline about not just the importance of Saturday afternoons, but the importance of that for their investment decisions in new generation aircraft, and it's that drives the overall benefit in noise, and in all the focus on Saturday afternoons, it's important not to lose sight of the fact that yes, there will be flights on Saturday afternoon, and yes, certainly people will notice those. But overall, throughout the whole week, the noise climate actually improves, and that's important. So what I've identified then from paragraph 81 onwards is just to identify the outstanding issues in relation to forecasting. So with LBN, there are 3 points. One, 82A is the point about downside risks. Second one, the ability of forecast growth to be handled by other airports. And C, the point about the rate of refleeting. And we'll come on and look at those. 84, I just draw attention to this with Hakan East, and Dr. Lane's closing submissions actually contained rather a lot on forecasting and whether or not the forecasts were robust. It is important, not to lose sight of the fact that Hakan East has not called a forecasting expert, whatever expertise Dr. Chapman may have. I mean, he doesn't himself purport to be a forecasting expert, and therefore one needs to bear that in mind when you are giving weight to some of the criticisms that Hakan East level at the forecast. So I'll go through then from para 86 onwards, these various identification of issues. The first downside risks. Again, I don't think I really need to read all these out. But we note a number of points, as you can see from paragraph 88. Dr. Smith has provided no coherent explanation as to why the short-term performance of the airport was not considered material to his forecast of 2031 at the time of his June report, but were relevant some 4 months later. The second one, the very purpose of producing the slower growth forecast is to identify what the effect would be if there was more downside risk. And we just draw attention to the fact that Dr. Smith didn't review that for whatever reason. I'm not suggesting any bad reason, but he just didn't. And thirdly, Dr. Smith hasn't produced any alternative forecasts that could be taken into account for the purpose of determining the appeal. Contrast that with some other airport inquiries where there are alternative fleet mixes or alternative forecasts or alternative growth rates. This is not one of those cases. There are just a series of fairly general comments on downside risks, which paragraph 91, he very fairly accepted that there was no specific evidence to support these factors, but he said that they were based on common sense and reading the newspaper. We say that, in contrast, Mr. Congdon's evidence is a very detailed explanation of a number of reasons for the slower rate of recovery at London City Airport. You're familiar with those. She identified them in the proof. She went through them in her oral evidence. I don't need to read them all out. But the point as well to make is that we say that, it's not appropriate when looking at long-term forecasts to 2031 or indeed slow growth to 2033 to base those on very short-term events. As Ms. Congdon pointed out, the growth to 2031 or 2033 is not going to be a perfect straight line. There will be years that are above a line of an average line and years that are below, and simply pointing to very short-term factors really tells you very little about what's going to happen in the 2030s. Dr. Smith also sought to criticize a number of the macroeconomic inputs to the modelling. This is paragraph 94. Again, we reject this, and paragraph 96, once again, Dr. Smith himself accepted that he had no evidence to support any of the factors he relied on to criticize the modelling inputs. So you will put what weight you think appropriate on all of that. From paragraph 97 to 99, I just touched on the point about accommodating growth at other airports. I've touched on that already. I don't need to go through it again. And from paragraph 100, the text on factors affecting refleeting. I then go on to cover business travel from paragraph 101, and there are a number of points here raised by Dr. Chapman about the elasticities of demand, which are used by the Department of Transport, and which we also used. Paragraph 102 makes 4 points about those which we say show that they are perfectly appropriate and robust for use in this inquiry. Again, paragraph 104, Dr. Chapman sought to argue that there's been some sort of structural change that's not reflected in the elasticities. We, again, reject that the elasticities are dealing with very long-term relationship between, GDP and demand for air travel, and over the period that they've been developed from 1986 to 2017, there have obviously been a number of economic shocks, and the elasticities are calibrated to reflect all of those. They are good for those types of changes. So we reject the the suggestion that these are in some way not appropriate. They are. So 105, just the conclusions on forecasting. I'll read those two paragraphs. The forecasting methodology used by York Aviation has been designed to address uncertainty and produces forecasts that are robust. The scope of disagreement largely centres around the likelihood that growth will be slower than anticipated. And this very issue has been addressed in the production of slower growth scenario. Although not having reviewed this forecast, Dr. Smith, as I've said, was unable to comment on it. Whilst criticisms of the inputs to the modelling and the use of the DFT elasticities has been advanced, no party has proposed any alternative. Dr. Smith accepts that very many of his downside risks are not supported by any evidence whatsoever. Indeed, there's no dispute that it is appropriate to assess the characteristics of the airport at 9 MPPA for the purposes of the environmental statement, and that the rate of refleeting assumed is reasonable. And that, Madam, is actually a hugely important point, because for all the argument about downside risks and everything else, we're applying for a capacity of 9 million passengers per annum. And Dr. Smith, and indeed the council, and indeed Hakan East, accept that it is the impacts of a 9 million passenger per annum airport that should be assessed. And as I say, if it arises 2 or 3 years earlier or 2 or 3 years later, no one is suggesting that we haven't correctly assessed the effects with that variability. It makes very little difference, and therefore, all these criticisms about the rates in growth, in a sense, lead nowhere. They lead absolutely nowhere, because you're still asked to assess a 9 million airport and the effects of a 9 million airport. So for the reasons explained above, the airport's forecast of business passenger growth is robust and entirely appropriate. And once the methodology adopted by York Aviation is properly understood, many of the apparent points of dispute simply fall away. They're just, there's nothing to them. So socioeconomic benefits. Again, there's an introduction with some general scene setting, which I hope is important. Paragraph 110, 111 deals with the scope of the disagreement at the close of the inquiry. And again, it is important to note that the council doesn't challenge the scale of the socioeconomic benefits as assessed by York Aviation, and Dr. Smith, made that clear. And it's also, of course, in the statement of common ground. This has always been common ground. The only issues raised by the council in its evidence relate to the past record of meeting local jobs and targets and the timing of the realisation of benefits in relation to environmental effects. I'll come on and touch briefly on that. For the reasons explained later, though, both of these issues are based on a misunderstanding of the evidence. The points raised by Hakan East are slightly more wide-ranging, but relate principally to 3 areas namely the need to carry out a web tag appraisal, the relevance of the tourism deficit created by outbound travel, and the extent to which there will be displacement. Hakan East has also sought to argue that business productivity benefits have been overstated. However, with respect, this argument is merely a consequence of Dr. Chapman's arguments on forecasting business travel. For the reasons explained, the DFT business travel elasticities used by York are appropriate. But again, I'll touch on it. So there's then a long section again on the policy context, which I won't read. And from paragraph 121 on the wider context, again, I won't read through all of that. From paragraph 125, that sets out the airport's assessment of socioeconomic benefits. Again, this is the sort of positive case part, and it deals with the approach to the assessment, direct, indirect, induced effects, GVA, wider economic impacts, the timing of benefits realization, and obviously you will read all of that. So we get to paragraph 137, outstanding issues in dispute. Sorry, I just drink my tea. So as noted above, the scope of the dispute in respect of socioeconomics is in fact narrow. There's no dispute with LBN about the methodology for assessing socioeconomic benefits, the scale of those benefits, or the fact there is compliance with policies J1 and J3 of the local plan. The sole outstanding point of dispute with the council is whether the weight to be afforded to the benefits ought to be reduced in the light of the very small shortfall in jobs for local people generated by the airport against the targets in the CADAT 1 Section 1 obligation. In other words, historic job delivery. You'll remember I asked Mr. McFadden about this. And there are three outstanding issues, as I identified above, with Hakan East. So I'll deal with each of these now, and I'll read a little bit if that's okay. So historic job delivery, LBN's argument on the extent to which local job targets have been met goes not to the scale of the socioeconomic benefits, which is agreed, but the weight that should be afforded to these benefits in the overall planning balance. In the officer's report, the council identified that there were certain targets within the CADAT 1 Section 1 agreement that had not been met. The report noted, however, that the airport had provided reasonable justification why this was the case, and this included the difficulty in carrying out background checks, driving license requirements, and employability skills. It is important to be clear that this concern does not relate to the numbers of jobs related at the airport. It relates solely to the proportion of those jobs that are held by residents from the London Borough of Newham and, respectively, the local area. As recorded in the officer's report, the matters relates primarily to the difficulty in carrying out background checks to determine whether or not an employee was resident of the local area. This has been particularly influenced by the effects of the pandemic. It's notable that in the latest set of data in the officer's report, the percentage of jobs for Newham residents was only 1% below the target, but the level of jobs from the local area was 9% over the target set out in the Section 106. This demonstrates that while the extent to which local job targets are met will inevitably vary over time, this should not, we say, diminish the weight to be attributed to job generation overall. In the light of London Borough of Newham's acceptance as to the nature of this issue, there's no justification for reducing the weight to be given to the socioeconomic benefits of the proposed development. Now, this section actually was sort of dealing with a Newham point, but 145, I just note that Hakan East also raised a point about
historic job rates and the potential effects of further productivity improvements in relation to the number of jobs that will be created. First, I say it needs to be recognised that Ms. Congdon has already taken into account productivity improvements in her employment forecast. But secondly, and importantly, even if there were greater productivity improvements than she has assumed into the future, any such additional productivity increases would apply both in the development case and in the do minimum case, such there would continue to be a net increase in employment between those two cases. So you can't have one without the other. You can't say, well, look, there might be productivity increases, you won't get as many jobs. Well, yeah, if that's true in the expanded airport case, it's also true in the not expanded airport case. So between the with and without development, there will always be this difference, the additional jobs. So the next point is the WebTag point. The relevance of the WebTag appraisal guidance to the appeal has been the subject of much debate. Dr. Chapman's arguments are not new. They have been raised repeatedly by him at recent airport appeals, and there is yet to be an airport decision in which these arguments are accepted. Before considering the evidence on this issue in detail, there are, however, a number of important preliminary points to make. It is no part of Hakan East's case that the Secretary of State cannot grant planning permission in the absence of a full WebTag appraisal. Accordingly, there can be no dispute that there is no requirement to carry out a full WebTag appraisal in support of the proposed development. Indeed, Dr. Chapman's argument that a planning application by a private developer and or determination by the Secretary of State on appeal or call-in is a government intervention has been considered at a number of recent planning appeals and consistently rejected. And in the footnote, I draw your attention to the various appeal documents. At its highest, therefore, Hakan East's case is that the WebTag guidance is relevant as a matter of best practice, and that a full WebTag appraisal would be useful for determining the appeal. There is no dispute that a WebTag appraisal has not been requested by the Council, the GLA, the Planning Inspectorate, or the Secretary of State in the context of this appeal. It's no part of Hakan East's case that WebTag should be used to assess the environmental effects of the proposed amendment arising from noise. Hakan East's case is solely that a WebTag appraisal is relevant to understanding the scale of economic effects of the proposed development, which requires environmental effects to be monetized. With regard to the usefulness of a WebTag appraisal, it's common ground that WebTag is a blunt instrument. Dr. Chapman himself explained that there are lots of nuances that are not captured by monetization, as WebTag necessarily relies on simplifying assumptions. Against this background, the scope of the outstanding dispute is whether the WebTag appraisal would be useful for assessing the economic effects of the proposed development in the determination of the appeal, such that the absence of such an appraisal weighs against the grant of planning permission. The airport's firm position is that while such an appraisal may be taken into account and seem to be implied by Hakan East in its closing that we said that it couldn't be, no, whilst it may be taken into account, we say it's just not useful and therefore should be given limited, if any, weight for the following three reasons. First, as explained by Mr. Bashforth, carrying out a full WebTag appraisal creates a parallel balance to that of the overall planning balance. It's simply not clear how the WebTag appraisal maps onto the statutory framework provided by Section 38(6). This means that whilst a WebTag appraisal can be produced, it's very difficult to know what to do with it in the decision-making process. This is why the WebTag guidance makes clear that planning decisions are to be considered in the normal way. This difficulty is confounded by the fact that WebTag appraisal incorporates matters that are already taken into account in the conventional planning balance. One such example is the way in which noise effects are accounted for. In the present appeal, there is no dispute that noise effects from the proposed development have been taken into account through the assessment in the environmental statement. However, the effect of Dr. Chapman's approach is that these effects are taken into account both as an output of the environmental statement and in terms of reducing the socioeconomic benefits of the proposed amendments through the monetization of changes in noise within the WebTag appraisal. Such an approach leads to a double counting and highlights the difficulty with seeking to incorporate such analyses into the planning decision making as opposed to options appraisal. Second, if the Secretary of State was minded to give weight to Dr. Chapman's appraisal, it's important to note that it continues to represent a significant overestimate of economic costs of the environmental effects of the proposed development. In Dr. Chapman's rebuttal, he sought to monetize the noise effects of the proposed development in accordance with WebTag. The WebTag workbook ascribes a monetary value for changes that move exposure from one dB band to another. In Dr. Chapman's rebuttal, he assumed that every person reported to experience a change between 0.1 and 1.9 dB in the environmental statement, experienced an increase in noise of 1 dB, the midpoint of the band. As a result of Mr. Greer's evidence, Dr. Chapman adjusted his assessment based on the tables in Appendix 1 to Mr. Greer's proof. However, as explained by Mr. Greer in his evidence and in the notes submitted on behalf of the airport in response to Dr. Chapman's updated assessment, the results in the environmental statement still show that the noise increases are lower than the adjusted figures used by Dr. Chapman. The average change in noise is in fact only 0.3 dB. Not only does this render Dr. Chapman's monetized figures unreliable, but it highlights the difficulty with using WebTag appraisal for these purposes. For the reasons explained in the airport's note, there also remains issues with Dr. Chapman's monetization of carbon emissions. In particular, Dr. Chapman's figures do not properly adjust for the displacement of carbon as required by the guidance. Indeed, if the WebTag guidance were properly applied, Ms. Congdon's analysis in her rebuttal to Dr. Chapman's updated monetized figures shows as a result, the results would indicate higher social welfare benefits than assessed in the need case, including the cost of carbon. Third, the lack of a WebTag appraisal was specifically considered by the panel of inspectors in the Luton P19 decision, who had regard to the consideration of the matter in the Bristol decision. The conclusion reached by the panel was that the lack of WebTag appraisal did not weigh against the proposals. This was accepted by the Secretary of State. Conclusion: there is no requirement for such an appraisal to be carried out. The absence of such does not weigh against the proposals. It is readily apparent that the attempt to monetize environmental costs within the framework of WebTag is fraught with difficulty and ultimately not very useful. For these reasons, the airport considers that Dr. Chapman's appraisal should be afforded little or no weight in the planning balance. And then we come on to displacement. I'm not going to read all of this out. What I would just say, and you can see it in paragraph 156, we have here explained and disaggregated the three types of displacement as did Ms. Congdon. That is passenger displacement, aircraft displacement, and displacement in terms of employment. Those three are different and are dealt with in a different way. I don't need to read it all out, but it's wrong to say that, oh, you know, we hadn't taken displacement into account and now we have taken displacement into account. Displacement was always recognized, madam. It is that you know, in the socioeconomic you know, costs, it is that cost of people having to travel further to the airport that is not their airport of that is not their airport of choice. And we recognise, of course, that employment as well could be displaced. The argument is not, could it be displaced to somewhere else? The point is that these jobs are important locally. They're important in Newham and Tower Hamlets and Greenwich and Redbridge and other local boroughs, these areas of London that have very high indices of deprivation. And that's why it's important. Yes, you can displace the jobs down to Sussex or up to Hertfordshire or places like that. But actually, it's East London, we say, where these jobs are particularly important. And that's the case we put forward on this. Outbound, para 159, outbound tourism. I don't really need to say very much about that. This is an argument that is often put forward, but frankly, there just isn't any UK policy that UK residents should not be allowed to travel abroad in order to improve our balance of payments. And one can imagine the effect on the economy and the very successful international multicultural society that we live in if people were told here, well, look, you can't travel abroad. And again, what people sometimes forget is this is an island. We only have one land link with the rest of the world, the Channel Tunnel. Everything else goes by air or by sea. And for an island, air links, are very important. And it's no part of government policy to stop people travelling, whether for business or indeed for leisure, or to visit their relatives or whatever else it is that they want to do. So the conclusions on the socioeconomic benefits. The socioeconomic benefits of the proposal are substantial, and their delivery in this area is strongly supported by policy. Importantly, they represent an increase over those delivered in respect of CAADP 1, which is a material change from when the planning balance was struck in respect of that application. And again, this point was made that, oh, well, you don't take into account the employment benefits. No, there are additional socioeconomic benefits of this development. Having regard to the levels of unemployment and deprivation in the area, the significant weight should be afforded to these socioeconomic benefits. And the introduction of operations on Saturday afternoons is integral to the realization of those benefits. Noise. There again, there's an introduction that sort of sets out the overall scene. From paragraph 166, I set out the scope of the dispute at the close of the evidence. I don't think I need to read all the way through that. I identified there what the issues were with London Borough of Newham and also with Hackney East. From paragraph 172, I again give one of these overall summaries of the policy context, which, as I say, is important, both national policy and local policy context. From paragraph 191, I deal with some wider contextual points. The point, it was put again this morning, that the airport is unique. No, the airport is not unique. I mean, or you could say that all airports are unique, but it's not unique in terms of its proximity to residential development. Lots of airports are near residential development. Existing controls are identified there. And then para 194 is that positive case, the assessment of the noise effects matters. Firstly, matters of approach, I don't need to read. And then from 205, the summary of effects, and you can see they've been divided into 207 daytime noise, 209 nighttime noise, and 211 weekend noise, and 212 the sensitivity tests. I do deal at para 217 onwards with embedded mitigation and compensation, and from 220 with outstanding issues in disputes. And maybe this is where we need to now focus. So 220 deals with this, or identifies this very narrow point between ourselves and Mr. Thornley Taylor, which is, you know, he completely accepts the 16-hour, 92-day LAQ metric and the 8-hour metric and what those things show. His narrow point is simply that change from Saturday afternoon is not captured in a separate metric. And you know that we put forward obviously a weekend metric. The council thought it appropriate, but he feels that doesn't cover the issue. So that's an issue between us. 221, here we've got the 3 Hackney East issues: the use of the citizen survey, the significance of noise effects outside the 51 dB contour, and whether the results of the citizen survey cast doubt on the correctness of the contours presented in the environmental statement. So I'll kind of deal with these points now. So paragraph 223, as set out above, there is now nothing between the council and the airport about the technical noise effects. The environmental statement demonstrates that the proposed amendments would not give rise to significant effects from noise, either during the day, at night, or on the basis of both the conventional and supplementary metrics at the weekend. Notwithstanding the council's acceptance of the approach in its scoping opinion, LBN no longer considers that the weekend metric can be used to inform decision-making. Even if the weekend metric were to be set aside, however, there is no technical evidence that is capable of supporting a conclusion that the proposed amendments would give rise to a significant noise effect. And there is a difference here, Madam. My learned friend, Mr. Straker, made many references to his bike staffs. And there is no doubt that the noise will be noticeable. But that's not the test, whether the noise is noticeable. The point is whether it gives rise to a significant noise effect. And one has to consider that within the context of the established metrics, but also noise policy, including the noise policy statement for England. But as I continue in that paragraph 224, it's because of this that there is no technical evidence that the council is forced to invite the Secretary of State to reach a, quote, value judgment as to the significance of Saturday afternoon operations. In other words, to depart from the conclusions of the environmental statement in order to conclude that there would be a significant effect, notwithstanding that there's no technical evidence to support such a conclusion. And it's a point that I put obviously to Mr. Thornley, except that the sonar data surveying various London airports includes people's reactions to Saturday afternoons, because all other airports include Saturday afternoons. It's not as though that reaction, when you apply the dose response curve and you apply it to the noise, it includes people's reactions to being overflown on Saturday afternoon. There's no dispute about that. Mr. Thornley Taylor's point is that people may respond differently because of change. In other words, a sort of an on-off, the bypass that is moved closer to your house and suddenly there are cars going past you where there weren't before type of effect. But it is important to note that on all the proper matrix, which include the people at every other airport on which these contours and the dose-response relationship is based, includes Saturday afternoons. That's not extraordinary, it's actually the norm. So 225, the airport acknowledges the concerns of residents that have been raised. Indeed, it was because of residents' concerns that the airport scaled back its plans for Saturday operations in order to protect Saturday evenings. The airport accepts that it is plainly the case that noise from these operations will be heard by those within the noise contours and even those outside the noise contours. However, the central plank of government policy is the balance between the economic and consumer benefits of aviation and its social and health implications. The overarching air noise policy statement makes clear that the way in which this is achieved is by requiring the mitigation of noise effects, quote, as much as practical and realistic to do in order to limit and, where possible, reduce total adverse impacts on health and quality of life, total adverse impacts. The use of the words health and quality of life in the OANPS is important. And this is clearly a reference to the approach in the noise policy statement for England that relates directly to those issues. Furthermore, government policy recognises that even where there is an increase in adverse effects, even where there is, and there isn't here an overall increase, but even where there is, these can be offset by socioeconomic and consumer benefits. London Plan Policy 2 recognises the need to avoid placing unreasonable restrictions on noise-generating uses. In this instance, there is no dispute that the total noise effects will be reduced by the proposed amendments. In real terms, this is a benefit for those living within the noise contours. But this benefit can only be achieved if the conditions are created in which it is viable and attractive for airlines to refleet to new generation quieter aircraft, which have greater seating capacity, amongst other benefits. As explained by Ms. Compton, Saturday afternoon operations are vital for enabling airlines to use their aircraft efficiently. Without the Saturday afternoon slots, the incentive to refleet created by condition 89 would not exist. In reality, therefore, the reduction in the curfew facilities facilitates a reduction in the total noise effects. Nor is there any dispute that the airport's proposals comply with national policy requirements in terms of mitigation. This is not a case where any party has identified additional mitigation that could be provided. LBN's case is simply that there is no means of mitigating the effects of operations on Saturday afternoons. As explained further below, in respect of the planning balance, the airport considers that the conclusion of the assessment in the environmental statement and the agreed compliance with national noise policy in respect of mitigation means that the proposed amendments are in compliance with development plan policy. To the extent that any impact on amenity arises, it is capable of being outweighed both by the beneficial noise effects and the substantial socioeconomic benefits of the proposed amendments. Then there's a section on impact on amenity, and that deals, amongst other things, with the use of outdoor space. I'm not going to read all of that. I think I might pick up at para 233, noise effects below Lowell. The airport's environmental statement indicates that new generation aircraft are between 2 and 3.2 dBA quieter than their old generation equivalents on arrival, and between 4 and 5.4 dBA on departure. And these are based on measured noise data. The primary argument advanced by Hakan East in respect of the citizens' science study is that it demonstrated that those outside the Lowell contour will not benefit from quieter effects of new generation aircraft. There are 2 points to be made in response to this. First, the results from the citizen science survey are from locations substantially outside the Lowell. It's the Lowell, i.e. the lowest observed adverse effect level, that is identified by government as the level above which adverse effects on health and quality of life can be detected. The noise performance improvements relied on are of primary relevance to those within the Lowell contour, where government policy requires that adverse effects are mitigated and minimized. It's for this reason that noise levels further afield from the airport are not calculated as part of the noise assessment. Whilst it's perfectly proper to take into account noise effects occurring outside the Lowell, the assessment of effects does not need to be the assessment of effects does need to be undertaken within the context of government policy, and in particular the MPSE. So again, it was suggested by Hakan East that we'd said you couldn't take these into account. We haven't said you can't take them into account, but that needs to be done in the context of government policy on these matters, which is absolutely clear. As explained by Mr. Thornley-Taylor, it's not surprising that close to the airport, the noise benefits of the new generation aircraft will be more significant. And then the quotation there is the one that was drawn attention to once or twice. It's the point about during the takeoff and landing phase, aircraft noise is dominant, and that's where the new generation aircraft are materially quieter, but further away, the noise tends to be more dominated by airframe, and therefore the noise of the engines plays a lesser part than it does, closer to the airport within the Lowell contour. The fact that the benefits of the new generation aircraft are more significant within the contours than outside the Lowell contour does not therefore have any bearing on the noise effects that government policy requires decision makers to have regard to. So that was the first point. Second, in any event, the results of the CSS are themselves inherently unreliable. As explained by Mr. Greer, figure 3 shows measurements levels across the 6 sites. All of those sites are beneath the level section of the aircraft descent, such that the results of the measurement should be the same. The aircraft at the same distance, same type of aircraft are being measured. They're the same distance above, because we're told that they're in the shelf part of the arrival. However, the results show a 13 decibel variation. Bearing in mind, 10 decibels is a doubling of noise. That's more than a doubling of noise between aircraft, indicating that it is unreliable for the purpose of drawing out a 1.7 dB change between different aircraft types. That's not to be critical of the individuals, but obviously there's a huge difference between people holding up iPhones in order to measure noise and that being done with properly calibrated equipment. There is therefore no dispute that the benefits of new generation aircraft are more significant within the Lowell contour. That is the area in which noise benefits are relevant to the decision making in policy terms. That's not to say that the airport does not want to better understand the performance of the new generation aircraft during overflight further from the airport, but simply that it does not weigh against the proposed developments. Indeed, the airport has already carried out monitoring between July and October last year in order to understand the difference in performance of the new generation, the new aircraft types. And as explained by Mr. Greer, the airport hopes to repeat this survey in order to gain a greater understanding of these effects. The implications of the CSS for the noise contours. During the course of the inquiry, Hakan East sought to argue that the output of the CSS raises doubts as to the correctness of the noise modelling. Particularly, it was suggested that the Lowell contours may in fact be considerably larger than modelled, As explained above, the locations from which the data was collected as part of that study are significantly outside the Lowell contour. The Lowell contour is wholly within the final stages of arrivals and the primary climb out, as these are the noisiest activities. The noise data that is used in the environmental statement in respect of these stages is robust, as it is based upon the airport's long-term noise monitoring, which is operated in accordance with noise categorization scheme. This is subject to ongoing review by LBN and reported in the airport's annual performance review. Hakan East's point developed in cross-examination of Mr. Greer that there is no noise monitoring of the 51 and 50 dB contours misses the point. As Mr. Greer explained, the contours are developed using the noise characteristics of each aircraft at source. The attenuation of noise with distance, i.e. the height of the aircraft above the receptor, and then verified by noise monitoring at appropriate locations. This is a well-recognized approach to aircraft, to air noise modeling at all airports. Indeed, this meets the CAA's requirements and does not require noise monitoring at each and every location and or contour line. It relies on the laws of physics. You know, there's a noise from the aircraft and it's a certain distance away from the receptor. That's the attenuation point, and you check that at some representative points, but you don't need to monitor every single point. The measurements collected from locations under the level flight path as part of the CSS, therefore, have no bearing on the modelling that underpins the size of the contours. So conclusions on noise. The proposed amendments will introduce flights on a Saturday afternoon when there are currently none. However, there's no dispute that on the basis of conventional noise indices, this will not give rise to a significant adverse effect. Moreover, the introduction of Saturday afternoon is crucial to delivering overall noise improvements from new generation aircraft throughout the week. In OANPS terms, there is no dispute that the total noise effects are reduced as a result of the proposed amendments. Coupled with the overall reduction in noise levels, the package of mitigation measures that are currently in place in respect of noise will be enhanced as part of the proposed amendments. In particular, the extension to the intermediate tier scheme through a new weekend noise eligibility criterion goes well beyond the sole and therefore will produce a real noise benefit for many thousands of people throughout the week. And I draw attention in the footnote there to Satnam again, and us discharging the burden, and clearly we have discharged any evidential burden upon us. Other matters, I won't read this section, but the other matters draws on those other things that in the case management conference we were asked to cover, so carbon and climate change, scope of the dispute and the airport's assessment, outstanding matters in dispute. I'll read 255 if I may. This is policy T8 and the Mayor's 2030 target. Hakan East's position is that the difference between this appeal and previous airport inquiries is the relevant policy context. In particular, policy T8 of the London Plan specifically addresses the carbon emissions from aviation, in contrast to the development plan policies at issue elsewhere. Mr. Farmer made clear, insofar as policy T8 is construed in line with the 2050 net zero target set out in policy GG6 of the London Plan, and consistently with section 1 of the Climate Change Act, that there would be compliance with that aspect of policy. However, Mr. Farmer's position is that the publication of the Mayor's 2030 target has the effect of amending these policies in the London Plan, as supported as the supporting text refers to the mayor's carbon reduction targets. The airport's case is that the mayor's 2030 target is non-statutory in nature and does not form part of the adopted development plan policy. The nature of the document within which this target is contained is a paper for engagement that was in any event published prior to the government's Jet Zero strategy. The Jet Zero strategy is clear in reiterating that carbon emissions from aviation are to be addressed at the national level. The mayor's targets are plainly not capable of amending through the back door adopted policy, which is itself consistent with the statutory net zero target. And Madam, the Chokley decision makes clear that supporting text is not itself a policy or part of a policy, and nor does it have the effect of policy. And as I make clear there, furthermore, as made clear in the Dawn Homes case, it cannot impose a new or an additional requirement without the policy, outwith the policy or the plan generally. So there is no question, and I don't think Hakan East are seriously suggesting otherwise, that the non-statutory 2030 target in some way replaces the plan, or means that the London plan has to be read as if it now contains a 2030 target. That's plainly wrong. To the extent that the non-statutory 2030 target is taken into account as a material consideration, in circumstances where government policy is clear that emissions from national aviation are to be addressed at the national level, then very little weight, if any, can be attributed to the mayor's target. As explained by Mr. Bashwood, it is not an appropriate role for regional policy or guidance to be setting carbon targets for international aviation. Particularly, the test of significance used in the environmental statement has been endorsed by the High Court. The introduction of a non-statutory target plainly cannot render significant in EIA terms effects that have been found to be not significant in the environmental statement. Population health, again, I don't need to read through that, but it is important. And I come then to the sort of final section, planning policy and planning matters, and I'll read through this orally side. The airport's assessment of the overall planning balance depends on the evidence of forecasting socioeconomic and noise as summarised above, in addition to the assessment of those matters that are not identified as reasons for refusal. And it's not the purpose of this section to repeat the analysis of the evidence set out above, but to draw on that analysis in the context of the legal and policy framework. And in this first section, I make the point that there is no dispute that the proposed amendments do comply with a wide range of development plan policies, including those relating to service access, air quality, delivery of employment, skills and socioeconomic benefits, and energy. And I draw to attention to other socioeconomic benefits and the Beckton, Riverside and Beckton opportunity area. The policies referred to in the reason for refusal are the four that we are familiar with. The next paragraph, 265, just reminds us of what the duty is, and again the well-established point that it's not whether or not we comply with a part of a policy, or indeed the whole of a policy, or whether we don't comply with part of a policy or the whole of a policy. The test is whether we comply with the development plan as a whole. And that does mean the other policies, the ones that aren't in dispute, because clearly, as is well known, policies will pull in different directions, but we can't just ignore the ones that pull in favour of the development. So policy T8, the only parts of T8 that are in dispute, well, I had thought, were parts B and E. It's agreed that the proposed amendments comply with A and F, which supports the role of airports serving London in enhancing the city's spatial growth. No dispute that there's no breach of C and G, which relate to surface access, and parts C, H, and I don't apply. And although there were submissions on policy T, H, it's clear that that is a policy that relates in terms to general and business aviation, and this is just not a general and business aviation policy proposal. With regard to B, the environmental and health impacts of the proposed development have been fully acknowledged and appropriate mitigation provided. The ES provides a full account of the likely significant environmental effects using standard noise matrices and supplementary matrices. The environmental statement concludes that all changes in daytime and weekend noise are forecast to be negligible and therefore not significant in EIA terms. Proposed amendments will result in nighttime noise increases for a limited number of proposals, properties above Seoul, but those properties are already within the sound insulation scheme. No dispute that the reference to mitigation and environmental effects corresponds to the requirements in the MPSE insofar as it relates to noise. No dispute that the proposed amendments comply with the MPSE, so that there is also compliance, we say, with this part of policy T8. With regard to the reference to the words overriding public interest if required, the meaning of the policy is not clear, and indeed the examination panel for this. The airport's position is that there is no such requirement in the present case, as the proposed amendments do not give rise to significant adverse effects. But even if there was such a requirement, there is clearly an overriding public interest in granting planning permission for the proposed development, as is clear from the need for the development as supported by national aviation policy, the many socioeconomic and consumer benefits, indeed the overall noise benefit. And then I deal with part E. Don't need to read all of that. Policy D 13. This is the agent of change policy. Don't need to read through all of that. SP2 and SP8. I don't need to read. I'll just sort of now come to the last few paragraphs. 274, compliance with development plan policy. Considering the above policies together, alongside those with which there is agreed to be compliance, the proposed amendments clearly accord with the development plan taken as a whole. The proposed scale of economic benefits, which are not disputed by LBN, and the national policy support for making the best use of existing airport infrastructure also weigh in favour of granting planning permission. There are therefore no material considerations indicating that the appeal should not be determined other than in accordance with the development plan. However, even if the proposed amendments did not accord with those policies identified in the reasons for refusal, the airport's case is that any such conflict would be outweighed by the other material considerations, indicating that planning permission should be granted. In particular, in addition to the benefits identified above, and then I list a number of points there. And then in conclusion, the scope of the objection to the proposed amendments is exceedingly narrow. By the close of the evidence, the council's objection relates solely to the impacts on amenity arising from operations on Saturday afternoons. There's no dispute that the technical evidence indicates that these operations would have no significant noise effects. The council invites the Secretary of State to depart from the conclusions of the environmental statement in order to reach a value judgment as to the significance of those effects. The airport's case rests principally on the assessment of those effects in the environmental statement. Any impacts on amenity arising from Saturday afternoons must be considered in the context of a reduction in total noise effects and the enhanced noise mitigation. The real noise benefits that the proposed amendments will deliver are inextricably linked to the Saturday afternoon operations. Standing back, the environmental effects of the proposed amendments are incredibly modest. These are to be weighed against the substantial socio-economic benefits that will be delivered. The proposed amendments represent an opportunity to make best use of the airport's existing infrastructure whilst delivering real-world benefits for real people, opportunities for skill, training, jobs, the chance to travel, increase economic activity in their area, and further investment in the place that they live and work. These benefits reflect key government objectives for levelling up areas of deprivation, strengthening international connectivity and supporting the role of airports as engines of economic growth. On balance, therefore, it is the airport's case that this appeal should be allowed and planning permission granted. Madam, so those are our closing submissions. I should just say that I owe an absolutely enormous debt of gratitude to my junior, Daisy Noble, who did all the heavy lifting on these closing submissions. You know, I did a lot of stuff with apostrophes and the odd comma here and there, but she did all the real work. And also I should say to the team at Town Legal and the client and consultant team who, you know, have also checked through everything and contributed and everything else. So I know I get to do the fun bit of reading, but actually this is not, I'd like to just say thank you to all of them. Thank you, Madam.
Okay. Thank you, Mr. Humphreys, and thank you, Ms. Noble, as well. Okay, so that brings everything to a conclusion in respect of this inquiry. A couple of points. I think I can't imagine there are any procedural matters, but if there's anything anyone wants to raise, please raise it now, just procedurally. Obviously, we've finished all the evidence and everything. It's silence in the virtual world, so I assume that's a no. I just want to extend the thank you from myself and Inspector Ayres to everyone that's participated in this inquiry, and we do appreciate that a great deal of work goes into the inquiry, but also behind the scenes as well, and we know there's lots of staff working in the background on this. So thank you to all of you for your hard work. The technical issues, I think, I think this has probably been the most challenging technical inquiry in terms of what's happened that I've ever had. We have been somewhat plagued, but thank you everyone for your cooperation. You're working together on it to resolve them, even if it did involve gaffer tape, surprisingly. It was a big help, and we did resolve matters, you know, not ideal, but we got there. So thank you everyone for that. We've still got to do the site visit in the Easterleys, so we will be advised of when the Easterley runway, where the Easterley approach is in use, and we'll endeavour to get down in the next few weeks. When we've done that site visit, I will, via the programme officer, just advise the party so you know when that happened, just as a matter of record, and it will be recorded in the report as well. All your hard work has finished now into some degree, whereas ours actually now really ramps up in terms of the report writing. So that's what we'll be doing now for the next few weeks. But yes, thank you again, everybody. We got there in the end. It has felt like years since doing this inquiry. Yes, I'll not say any more about that because I'm wittering now. But thank you, everyone. So I will formally close the London City Airport inquiry. Thank you very much.
Thank you very much, madam. Thank you.
Thank you.